Next bill up is Senate Bill 2930, makes various changes to process for access to government records, appropriates $8 million. There are significant amendments. Yeah. Yeah, I think it's appropriate that we read through them. You want me to read through them? You want to read through them? Okay. Folks, if you just be patient with us, again, please try to be respectful of everybody. We want to make sure we have the most up-to-date amendments.
So here are a quick summary of the major amendments proposed to Senate Bill 2930, first reprint. The original bill prohibited documents requested from data brokers. After receiving feedback from attorneys and regulated.
No, you have the wrong. Okay. Just want to make sure. Please give Office Legislative Services a moment as they download the correct set from upstairs to.
Okay. I have it.
You have it?
Yes.
Okay.
Power of technology.
Power Technology, you have it.
Yes.
The pressure's on.
Yes. The amendments for S2930 first reprint will add labor organizations, contractor signatories, nonprofit organizations to the list of parties exempt from commercial purpose. They would remove record request limitations and registration fees on data brokers. Remove the following from exemption from public record requests: notes, draft material, deliberative material, information relating to negotiating positions, logs of calls, logs of texts, logs of emails, and electronic or paper calendars for individuals. Specify legal next of kin, legal representatives, attending physicians when permitted by court, and courts may have access to visual autopsy records. Specify that releasing security footage is permitted as long as it does not compromise the integrity of the security system. Prohibit indecent or graphic images of a person's intimate parts from released by records request. Require the custodian to provide a requester with an itemized list of charges. Determine charges that are reasonable and places burden of proof upon requester to determine that charges are not reasonable. Allow public agencies to charge certain fees or not complete a request if the medium of the record requested is unavailable. specify that a request submitted anonymously will not be considered incomplete. Require the Government Records Council to create a uniform record request form that will be adopted by all public agencies. Allow a commercial requester to pay a special service fee to receive a record in 7 days instead of 14 business days. Specify that the court or Government Records Council may award a reasonable attorney's fee to any requester who prevails in any proceeding, but determines that a requester will always receive a reasonable attorney's fee if the public agency has been determined to have denied the record unreasonably, acted in bad faith, or knowingly and willfully violated the OPRA law. Require the Superior Court and the Administrative Office of the Courts to report certain data on actions brought before the court regarding record requests. Remove Police Record Access Improvement Task Force. Establish procedures for record requests with potentially indecent or graphic camera footage, and appropriate an additional $2 million for the Government Records Council to effectuate the purposes of the bill. Mr. Chairman, those are the amendments.
Okay. Thank you. Since we've all gathered a few weeks back, I just want to bring everybody briefly up to date what has occurred. First of all, Senator Bucco, in conjunction with the Senate President, has joined as a co-prime sponsor of the bill. Tim Lyden, our Executive Director of the Senate Majority, and Seth Hahn, Executive Director of the Assembly, have conducted a series of meetings with the coalition of working groups to work on the amendments. The following amendments were developed and requested by a coalition encompassing the Working Families Party, ACLU, New Jersey Citizen Action, League of Women Voters, Heidi Rosenstein, Rutgers AFT, and Steve Weitzman. I will share with you all amendments and all recommendations were not accepted as part of a compromise you all know between three parties, between the governor, executive branch, the Assembly, and the Senate. Many of their recommendations are incorporated into these amendments, and some are not. I think we will hear today that there are some folks and advocates who have concerns, but you also may hear that the League of Municipalities and Mayors have concern that we didn't go farther enough in modernizing this law, modernization of this law. So, for those who have been sitting here a long time, you know when both sides potentially are not totally thrilled, you may have a good compromise. Because I think at the end of the day, we have a compromise here. When those say, why touch it? We went back and looked at bail reform after only 3 years. Charter schools now are being looked at again after the recent reports in the papers about what's happening in certain charter schools. And here, back from the early 80s, we have a bill that has not been touched. Technology has changed how municipalities conduct business, social media and alike. So it was time to take a look at this and modernize it accordingly. So today the amendments are been submitted by a whole host of folks and groups. We've tried to accommodate those who have led the negotiation and tried to accommodate everybody the best they can. I also want to thank the Office of Legislative Services for working late last week to get it out, have it prepared so they could be circulated. I want to thank the press who was able to get hold of them and publicize them in the newspapers throughout the weekend and throughout the week. And again, today we've come to a compromise between the two houses and the executive branch. One area that still seems to be, one thing we all have learned through this process, it's not so much about transparency, it's about attorney's fees. That is what's driving a lot of the angst. It's about how much attorneys will get paid when requesting records. And I think you'll hear today as part of the testimony, when you hear some of the rates in excess of $500, $600 an hour, it's troubling. Municipal attorneys, most municipal attorneys in the state are capped somewhere around 180 to 200 bucks an hour. But I think you're going to hear today, it's about attorney fees and about a cottage industry of folks who are making a lot of money off the taxpayers in New Jersey. And I'm not sure how we could ever resolve that. We've done our best. So, thank you to Mr. Lyden, thank you to Mr. Hahn, thank you to all the advocacy groups for coming forward and doing the best we can to come to a compromise. Thank you to the League of Municipalities and the Conference of Mayors. We hope to conduct a very professional hearing today. And we have a lot of people who want to speak. We have higher education backed up. The presidents of the colleges are here. We're going to give everybody 3 minutes so please, we have a lot of written comments. Please summarize. I apologize. Typically, when we have large hearings, we have a little stoplight that goes on. The yellow light comes on. It gives you about 30 seconds. And the red light comes on. It's not working. You may want to OPRA, the Office of Legislative Services, to find out who broke it. But he's going to place up a yellow card when you're getting close to the 3 minutes. That means you can wrap up. So, with that, I'm going to call up Tom Cafferty, General Counsel, New Jersey Press Association, and Brett Ainsworth. Are you guys together, Tom and Brett? Yes. Please come up, and then we'll go to panels. I just want to give Tom an opportunity. Thank you, Tom, Brett. I want to give you guys the opportunity, but first, I have great respect for all the work that he's done with all of this over the years, so please provide your remarks.
Thank you, Senator, and members of the committee. Appreciate the opportunity. As Senator Starlow said, I'm here in my role as General Counsel of the Press Association. The Press Association was created in 1857 under the laws of the state. We represent and have as members daily newspapers, weekly newspapers, digital news organizations.
Folks, there's way too much background noise. Nobody can hear one word Mr. Captain say. And can you move the microphone a little closer?
Sure. See if that's any better.
Okay.
Thank you.
Thank you.
And we, as I said, we represent daily newspapers, weekly newspapers, digital news organizations. I previously appeared in opposition to this bill a few months ago. Unfortunately, I'm here today continuing that opposition. Despite the amendments, the bill remains deeply flawed. Many records that are currently available to the public will be cloaked in secrecy or otherwise made more difficult to obtain if the bill is enacted, and wrongful denials will be impossible for many to challenge. All of this derogation of New Jersey's long-standing commitment to openness and hostility to secrecy. We have provided you copies of our position paper with respect to this bill and its amendments and the prior bill, and I'm not going to go through all of those concerns we have. I'd like to hit on a few.
And if you can, and folks, forgive me, we have a hearing on the base bill. We're not here to talk about why you may not like or like not the Open Public Records Act. Today, we want to focus in on the amendments that are being made, what you like and what you don't like about the amendments. We're not going to go back and relitigate the whole bill. So please, we're here today to discuss the amendments. Thank you.
Thank you, Senator, and that's what I intend to do with my comments here. And happily, we were provided a copy of the amendments in advance of the hearing, and I appreciate that. The single, as the Senator said, and anticipated the objection would be the single most objectionable provision of the bill is the removal of OPRA's effective removal of OPRA's enforcement provision, the mandatory attorney's fee award to a prevailing requester. The bill replaces the amendments, the mandatory fee award, with a general provision for discretionary attorney fee awards, limiting mandatory fee awards to cases where there is a determination that the public agency, in the word of the bill, acted in bad faith, a term that is not defined in the bill. This change alone will severely and negatively impact the landscape of access to government records in this state. OPRA's current mandatory award of attorney's fees plays a critical role, as I said, in ensuring transparency, a role that has been recognized by our Supreme Court multiple times. And I think it should not be lost that the current structure of award of attorney fees requires, number one, the court to find that the denial of access was wrongful, and number two, that the fees are reasonable. So there is judicial oversight as it exists now for the award of attorney's fees. Thus, changes I submit to this provision are unnecessary and only thwart public access. And I think it can't be lost that if this bill is passed, a court exercising the discretion to award attorney fees will exercise that discretion in light of what has occurred in the context of the passage of this bill, the opposition to mandatory award of attorney fees. And I suggest the court, cognizant of that, will be very careful at even exercising discretion to award attorney fees. We have suggested in the process changes to the current mandatory award of attorney fees, making attorney fee awards mandatory except in certain circumstances. Those circumstances would be if a requester refused a reasonable extension. Another circumstance we propose is if there was confusion on the face of the request and the custodian asked the requester to clarify and the requester refused to do so but went to court. And so we propose those to address what we understand to be the concerns of custodians in the context of mandatory attorney fees. And we did it. I have my own history as I've been a municipal attorney for many years in 4 towns. I've been a planning board attorney. I understand the other side of this equation, and we tried to address that, but that is not where we are. A second problem.
I'm going to give you a little bit of latitude because we're trying to give everybody 3 minutes. I interrupt you a few times. I'm going to give you a little bit more latitude because you are representing the entire press.
And I will finish in another minute.
Sure. I want to give you latitude.
Thank you. The bill creates a rebuttable presumption that any special service charge fees are presented by the custodian are reasonable. Effectively, though, this is an irrebuttable presumption because the very facts that support the imposition of the special service fee are peculiarly within the possession of the custodian. And so, effectively, to challenge that presumption, you're going to have to go to litigation. You're going to have to go to discovery. And with the prospect of not even securing attorney fees if you succeed, who's going to do that? Again, effectively, that's an irrebuttable presumption. The bill permits a custodian to not complete a request for records if it involves, among other things, if it doesn't, rather, identify a specific job title, an account to be served, etc. A whole host of conditions. What is not clear from that section is whether those conditions are conjunctive or disjunctive. If any one of those conditions that would allow a custodian to deny access are present, may they deny access or must all of them be present? The bill also contains numerous provisions that vest vague and unguided discretion in the custodian, such as allowing a custodian to redact from government records information that, quote, might reasonably lead to the discovery of a person's personal information. Or when a public agency, quote, has reason to believe that disclosure of such personal information may result in identity theft. These vague conditions with no guardrails can only have one result, and that result is, again, to thwart public access. In conclusion, I've had the privilege of representing the news media in the state for 52 years. That representation has included advocacy of transparency for government records before this legislature, as New Jersey moved in 2001 to adopt OPRA and abandon the archaic and limited right to know law. And it has included arguing for transparency before the courts of this state, including the Supreme Court. All the time arguing for records that are statutes that mandate access, well, legitimately respecting privacy interests or other significant governmental interests. And generally, the arc of transparency in this state has been for transparency. I am sad to say, unfortunately, that if this bill passes, that arc towards transparency will be reversed. I hope that this legislature takes a step back from the precipice and takes an opportunity to review these issues and do it in a way that we can reach an accommodation between the legitimate interest in access and the legitimate interest in privacy. And again, I say that NJPA,
Tom, I need you to wrap up, please.
NJPA stands ready to assist in that process.
Thank you.
Thank you.
If you could just hold, Mr. Ainsworth, go 3 minutes, and then we'll ask questions, if we have any.
Hello, my name is Brett Ainsworth. I am president of the New Jersey Press Association. I am also the owner and publisher of the Retrospect newspaper based in Collingswood in Camden County. I want to go to Tom's point about transparency. To me, that is the key fundamental aspect of OPRA. And the key fundamental aspect to enforce that is specifically the fee shifting mechanism. That is the mechanism that tries to encourage honesty in being transparent. I understand the legislature's desire to address the issues that a number of clerks at all levels of government have to deal with: custodians, records custodians. As a high school teacher of mine would say, this approach that you're taking is kind of taking a bazooka to shoot a fly. You might not hit the fly, but there's going to be a lot of collateral damage. And I'll give you an example. So,
Are there any amendments you would like to speak? You're speaking in general terms, so I just want to,
okay.
all right, what amendments are you concerned about?
Specifically, the approach against the fee shifting.
The fee shift.
Right, that's number one. There's a number of other things, and in that aspect, by taking away, we were involved in a case where the school board sued us for requesting a public record, and that was not us. We're a small operation. The school board has tens of millions of dollars budget, and they kind of exist in perpetuity. So that's the weight of government against our interest. It took 4 years to litigate. And it wasn't our choice, but that's what happened. It took 4 years to litigate, over $150,000 in legal fees. We get to the award part because it was wrongfully denied to us, and that was cut by more than a third. So that took 4 years of my life, a lot of expense, and there was still a haircut. And that's where you have to remember, this mechanism is there. So one of the things we need to think about is these records custodians, they are serving two masters. They're serving the public and the public's right to know, and they're serving the administration and the elected officials. Now, elected officials don't always want things public, and that's where the records custodian comes into play. And she needs to be able to say,
He or
well,
she, he or she, he or she.
right, she needs to, well,
He or she.
he or she, but most of the custodians I've ever dealt with are women.
They're mostly women, clerks are all women, okay.
Right, so, and in my experience,
I know some help.
agreed, but what that custodian needs to be able to do is say, we don't want to risk exposure to possibly this kind of suit, or this long kind of litigation to get this record, despite what the administration or despite what a public official might want.
Thank you, I appreciate it. I have a question, and I'll open up to the members. Both of you gentlemen have raised the issue about the fee shifting, the amendment on the fee shifting that you have concerns. I guess, Mr. Cassidy, you've served on a municipal, what are municipal, when you were a municipal attorney, if you don't mind, just ask you, what were you able to charge? What do most municipal attorneys in the state charge?
Well, your question to me goes back a number of years.
Okay.
So I'm not sure it's irrelevant to,
You're a young guy, so don't date your age.
back then, probably it was $125 when I was a municipal attorney.
Now it's about 200, 180, 200.
I wouldn't be in a position to say, but I suspect that's probably, of course, you know, the difference, and I always looked at it this way too, is, you know, number one, you were on a retainer, you probably also, in addition to an hourly rate, got a retainer, at least when I was township attorney in those towns, et cetera. So the hourly rate is, of course, not reflective.
Sure.
And I, you know, and the point Brett raises is legitimate. I've had public access litigations.
Sure.
I'm sorry, go ahead.
That's fine. I mean, the research that has shown is it's in $180 to $200 an hour. A lot of towns smaller towns especially, are capped that way. One of the recommendations during the negotiations, and I was not intimately involved in the negotiations, it was done by, as I said earlier, the majorities, the staff offices, and their attorneys. One of the recommendations that had come out was an amendment was to cap legal fees. Go back to shall be paid legal fees automatically and cap it at, say, $300.
Cap the hourly rate.
Cap the hourly rate at $300, but it shall. You know, we instead of may, we go back, the original bill had may, we go back to, shall, and make it at $300. Automatically, you get $300.
I guess my thought on that, and I don't know whether $300 is there.
Let's say $350.
Whatever, I think.
Is that number, do you think that's a fair number?
I don't think I'm in a position to answer that, and I'll tell you why.
Because it came back to us, that was recommended from many of the advocate groups, and a handful of attorneys came back and said, no, that's not enough. Because we want the ability, and some of the records that we have seen through some of the data that's provided by municipalities is $565 an hour, and some ask for a fee enhancement. I'm not sure what that is. Can you explain what a fee enhancement would be?
Well,
A 50% fee enhancement.
there are provisions in our court rules that would allow, in certain circumstances, the court to increase a fee award because of the unique difficulties of the litigation or things like that. So I suspect that that's what that question is. But to answer your direct question, I think what we're losing sight of.
But the question I have is, a fee enhancement would be 50% of, if they're requesting the court to give them 565, 50% of that on top of the 565, correct? Is that accurate?
If you talked about a 50% fee enhancement, and you had a base rate of whatever, $600, then in theory, the court could award $900.
9,
But here's the answer.
and that's what we see.
Here's the real answer. Why do we need a fee cap? You already effectively, I suggest, we have a fee cap in OPRA as it is. The court determines, as Brett alluded to this, the court determines a reasonable fee. Any of us who've ever been in, take it out of OPRA, we all wind up getting a haircut whenever you present a fee to a court for determination. That's just the reality of life. I've had an OPRA case where went on for years. The municipality raised every kind of argument, and the court appointed a special master to look at the fees and make a recommendation. So we have control of the fees today by judicial.
And unfortunately, I was a little disappointed. I was on the side of a fee cap. I thought 300, 350 would be a very fair fee. Automatically, the attorney gets it regardless, and that was outright rejected by the advocates. Many of the attorneys representing the advocacy groups are very small, saying absolutely not. We want the ability to go in and charge what we want. So that's the compromise we've come up with, the 2 tiers now where we keep in May, they were okay with, many attorneys have told us, keep May. And on the other piece, if a town is knowingly and willingly at fault, and they're just, and shame on those municipalities, they're gonna say that, shame on all those towns and counties, knowing and willing, then it goes to shall. So, I have no further questions. Anybody else questions? Thank you.
Thank you.
Michael Sherritt, New Jersey League of Municipalities, and he has a panel. I'm going to read off the panel of mayors that are with him. Adrian Mack, Mayor of Plainfield. Paul Medani, Mayor of Deptford Township. On that panel. Did I miss any mayors? You want me to call you guys up in a minute?
I'm here for you. You know that.
I'll go for it. I'm just gonna be a moment. For the record, Mike Serra, the Executive Director of the State League of Municipalities. And also for the record, Lori Bucklew, the Deputy Executive Director, and also our registered RMC will be presenting lead comments on the amendments later with a different panel. I just wanted to introduce this mayor's panel who can speak to some frontline issues and the impact of OPRA as well. I want to begin by, I'm going to echo your comments, Mr. Chairman.
Folks, please, I know even on our side, we have to, it's not fair to mayors who drove down here, anybody, please.
Thank you, Mr. Chairman, and thanks to you and Senator Bucco as well for all the work and the staff in putting together the amendments to this bill. You are correct. If the league, if local officials were able to write this bill, it would go further. And I think some of the issues that are not being addressed by the amendments, I would hope they would be addressed. The data mining issue here, for instance, could be addressed at some future date because it's a critical issue. But on balance, this is still a very good bill and it's worthy of your support, and I would ask you to support it as well. I'll note that this is Public Sector Recognition Week, and the records custodians in this state do a remarkable job at the municipal level, the county level, the state level, throughout. And I don't think there's any better way to recognize the hard work that they do by modernizing OPRA. Again, Lori will get into there's probably no better person in the state to speak on this issue than Lori as well. So she will speak into it. But if I could take one moment, I'm a stickler for a number of things and issues. You're probably going to hear today folks talk about 81% in a recent survey that came out of FDU. And with all due respect to the institution, you probably have seen reports of that survey. You might not have seen the question that was asked, which was so biased that I can't imagine anyone answered in the negative. I could read the question very quickly. The New Jersey legislature is concurrently considering a bill that would make it harder for citizens to access public records and limit what records they can request. Supporters of the bill say that answering public record requests can be a burden on municipalities. I'll take just a side note that they only mention municipalities. Opponents of the bill say that access to public records helps uncover corruption and illegal behavior. What do you think? Should the state limit access to public records or keep the system as it is? You can all judge the validity and the bias in that question. The fact that it does not address privacy issues, modernization, the fee shifting, I don't think captures really what the sentiment is. And I'll be honest, I don't know what the public sentiment is. If you did a unbiased poll, I don't know what the results would be. But I do know that FDU doesn't know either. So with all due respect to the institution, I think those results need to be taken with a grain of salt. With the mayors before us today, Mayor Paul Medani of Deptford, Paul Meir of Bethlehem, and Adrian Mack of Plainfield. So again, much appreciation to the sponsors and the staff for getting us to this point, and we do ask for your support. and you can, all the tough questions can go to Lori. That's the beauty of it.
If you
But,
could just let Mayor Matt.
yes, so thank you, Mr. Chairman. Paul, why don't you go?
Is Lori coming up on a separate panel later?
Yeah, she'll be testifying with John Donadio and John Burns on the Association of Counties and the School Boards.
Mayor Matt, please. All right. Yeah, Mayor.
Thank you, Mr. Chairman and the committee, and I want to thank the committee for the work on this issue, the League of Municipalities and Conference Mayors and the Clerks Association also, we can't forget about that. I want to talk about the amendments, and I want to share my experiences real quick, and I think it's relative to the amendments. And I don't think there's one elected official in this room against transparency. In Denver, we have no issue with our residents and legitimate news organizations using this statute, but I want to talk about the human element inside of the municipal buildings in this state. And basically what happens, I want to advocate for them, the clerks, the department heads, the folks who work in every department of municipal government. We're not trying to destroy democracy, we're trying to help protect the people who service democracy. So in Denver Township, real quick, so far I've had 200 open requests. That's not the police department. Only 3 of them were from residents of Deptford Township. The rest were discovery from lawyers, OPRA companies, Florida attorneys made a zoning decision, private companies doing research, developers, et cetera, et cetera, et cetera. Government workers are good people. I've been there for 25 years working with them as a part-time mayor. They want to help the residents of their communities. We had to hire a township, somebody in the township clerk's office just to process OPRA requests. We had a township clerk with 27 years of experience, retired December 31st in Deptford Township, who wanted to stay. She was the president of the Clerks Association one year. Fantastic individual, dedicated public servants. I literally sat in her office more than one time as she literally cried over OPRA requests. There was a developer who OPRA'd the township. It took her 12 months with extensions to fulfill this request, and her office. The developer never picked it up. There's 3 banker's boxes sitting in our building right now. 5 years ago, he still never picked up those documents. So I think that is relative to the amendments, not just one particular, but all of the amendments. We have to fix this bill. We have to give our public servants the tools they need to do the work of the people. That's what this is about. We have to fix this. It has to change. Thank you for listening to me.
Thank you.
Well, good morning to all of the members of the committee. I am here testifying as mayor of the great city of Plainfield. And I'm here to testify on the amendments and, broadly speaking, on the bill. Our clerk, staff and department heads and legal teams spend countless hours and tax dollars working on hundreds of never-ending requests which have gone like years beyond transparency for the public. This bill is a step in the right direction to establish order and allow staff to be able to do their jobs and serve the public. I, like most of you, like probably everyone in this room, believe that sunshine is the best disinfectant. But I, like everyone, also know that too much exposure to the sun results in unintended consequences, such as skin cancer. OPRA was created as a tool for transparency to our citizens and has morphed into a tool to allow for commercial businesses all around the country to profit on the backs of our taxpayers. This bill puts measures in place to help get the Open Public Records Act to its true intent. With the rise in violence in recent years across our country and our state, we've seen public employees become the targets of attacks, including judges, law enforcement, and their families. This bill will help safeguard personal information from the hands of those seeking to retrieve information for nefarious purposes. The OPRA law, while important and well-intended, has not kept up with the technological advances we have made over the last few decades. This bill helps to clarify requests for technology information that simply didn't exist when the legislation was created so many years ago. For example, security footage in municipal buildings and open-ended requests for thousands of emails. As members of this committee, I implore you to move this out of committee to a vote of the full Senate so that we could begin to save taxpayer dollars and help to provide the kind of true intent that was intended by the original legislation. And so as mayor, I support this bill, I support the amendments, and I implore you to move it out of committee to a vote so that it can become the law of the state of New Jersey.
Thank you, Mayor. And I know you're here representing just your city, but I also want to congratulate you on being in a different hat as president of the Mayor's Urban Association. Congratulations on that role that you played as well. Mayor?
Good morning, Mayor Paul Muir from Bethlehem Township in Hunter County and President of the New Jersey Conference of Mayors. I concur with my fellow mayors, so with that, it's going to be more of a summation. What we're here to do is achieve good government. What does good government look like? Transparency and efficiency. We're not reducing that transparency, we're providing greater efficiency. We've already discussed what our clerks have gone through. We understand that this bill provides for protections for our residents and our staff. It protects the townships against exorbitant fees from attorneys, and then it also allows our clerks to refer information to the website, adding to efficiency, and also allows less disruption to our offices. Bethlehem Township is a small township. I told my clerk where I was going to be today. Yesterday we received 5 OPRA requests, none of them from citizens requesting anything substantial. It was all commercial requests that we have to now fulfill in a small office. While we're small, we do represent probably the majority of the small municipalities within the state of New Jersey. So again, I implore you to move this out of the committee. I thank you for the amendments that you have provided. Of course, we would like to see some further steps, but we do support with what is here, and look forward to you supporting this bill. And thank you for your time.
And we acknowledge that many of the mayors, we heard from many of the mayors that they feel that we had the opportunity to go further, but we're falling a little short here, and we fully understand that. But as part of compromise, it's the first step. Thank you. Okay, thank you. Any questions? We're good? Okay. Thank you. Thank you, Mayor. Thanks for coming down.
Thank you.
All right, we're going to do a panel of Bruce Rosen, Sharon Pringle, Education Law Center, and Krista Cunningham. 3 minutes each, please. Get Bruce? Yes. Go ahead, sir. You representing yourself? I am. Okay, sir. 3 minutes.
Thank you. In looking at these amendments, first of all, I'm a long time, can you hear me now?
Yes, we hear you, sir.
I'm a long-time media lawyer. I teach media law at Rutgers Law School, and I was a reporter for many years for the Bergen Record. I appreciate what you were saying about the legal fees, but you failed to take into account the risk that's involved when you take these cases. Because
you're here to discuss the amendments regarding fee shifting, right? We're focusing on amendments.
exactly.
Okay. You're on the fee, and I think that's a recurring theme today. It's all about legal fees. Okay, thank you.
Okay, but the risk that's involved is substantial. What that what the current bill or the current law does, as the new anti-SLAPP law does, is create a bar to go after these cases. In the current state of the media, there is absolutely no money to send after people to provide to attorneys to pursue these cases. If the judges have ultimate discretion. They do not award fees. If you look at the frivolous litigation statute that's in existence here, which is 2A 1559-1, it's almost non-existent that given the same kind of parameters, the judges just do not award those fees. And that will be what will happen here. No one wants to impose fees on a municipality if they don't have to. No one wants to impose fees on lawyers if they don't have to. This just will be the end of OPRA as we know it. I know you think, well, we're protecting the municipalities, but what you're doing is clouding and ending transparency to a great extent because you're undermining the effectiveness of OPRA in so many ways. I heard you, Senator Sarlo, when you referred to the compromise, and the lawyers didn't want to take the cap, but that's not the only solution. Okay, it's not the yellow light or the red light?
That's the yellow light. You go through, yeah, you're about to. Keep going.
It's not the only solution. There's got to be another one because the way that this is set up for failure. It's set up to really prohibit creating a bar that will take these cases, especially for the media. Because I heard you earlier praising the media and praising the job they've done on this, and having done this for many, many years and having won fees and always judges picking at them and saying it's not reasonable, it's too much, there will be no bar for this. No one will want to take these cases and won't be able to take the cases.
Thank you.
Thank you.
Sharon, good to see you.
Thank you. Thanks, Chair Sarlo, members of the committee. I'm Sharon Kringle. I'm the Director of Policy and Strategic Partnerships and Communications at Education Law Center. And we join the chorus of New Jersey citizens, advocates, attorneys, associations, and public interest organizations that object to the amended version of S 2930. Even as amended, the bill still guts the Open Public Records Act and diminishes that law's effectiveness in shining a light on government operations. With democracy under attack throughout the country, now is definitely not the time to reduce transparency and access to government records. ELC uses OPRA on a fairly regular basis to inform our work on behalf of New Jersey students, and we cannot overstate its importance. We've rarely filed a lawsuit to obtain government records, but we strongly believe that a provision authorizing the mandatory payment of the reasonable attorney fees of a prevailing plaintiff is a critical tool that incentivizes a compliance with the law. Under the amended version of the bill, the prevailing plaintiff is only entitled to fees if it's determined that the public agency has acted in bad faith, an almost impossible standard to prove. This change will make it extremely difficult for people wrongfully denied government records to find an attorney willing to take their case, allowing unlawful denials to go unchallenged. A number of proposed amendments create other barriers to the effective use of OPRA, including, for example, increasing the amount of specific information requesters must include to receive the records. These provisions make the process unnecessarily burdensome and make it much easier for government bodies to deny requests for minor technical reasons. The bill also allows government agencies to sue requesters for seeking records with the intent to substantially impair the performance of government function. Substantially impair is a vague and undefined standard. Government agencies could weaponize it to retaliate against requesters and shield legitimate requests. To the extent that OPRA is being abused by commercial or other entities, we urge you to discuss the law's meaningful reform again in a way that still preserves its intended purpose. We ask you to please not advance this bill out of committee today. Thanks very much.
Thank you. Krista Cunningham?
Hi, my name is Carissa Cunningham, and I'm a researcher and professor at Rutgers University. I'm here to talk about the amendments to this OPRA bill because as a researcher, I know how important it is to have transparency in government records. It's important for us as researchers to do our job to have access. And if these attorneys' fees are not addressed, and allowed to be what they are currently, this would mean that working class and poor people will have an even more difficult time accessing public records. I speak as somebody who's part of the Uncommitted New Jersey campaign, a working class movement that is looking to vote uncommitted to basically push for a ceasefire in regard to Palestine. OPRA requests have been an important part of our campaign.
Ma'am,
OPRA requests are an important part.
ma'am, what amendments are you here to speak on?
S2930.
What amendments though?
The one about the fees.
About the fees, okay.
Yes.
We're going through Palestine.
Palestine, the Palestine
This
issue.
is related to what I'm speaking about.
Ladies, just focus.
Thank you. I can speak about Palestine if I want to. Thank you so much, sir. I appreciate you intervening.
I'm going to just ask you just to stay on the bill that's here today. You have every right to talk about
Palestine is a question. As the campaign that I am working on called Uncommitted New Jersey, which is a working class movement of taxpayers, right, who care about the issue of Palestine, right, have used OPRA records requests, all right, to do our campaign. They have been absolutely important. And I will say that this bill is in direct conflict with that and is in direct conflict with our interests. Thank you so much. I appreciate your time. Please do not interrupt me again. Thank you so much.
We do have a group of folks from Rutgers faculty, AAUP. If you could just let us know, there's about 6 or 7 have signed up. If you could just let the sergeant arms let us know who's going to be representing the group. We're not going to get to yet, but you'll be representing the entire group. All right, just let the sergeant arms know who that individual is, and once we have that, you can get up and speak on behalf of Rutgers AAUP. Next up is Melissa Marks, League of Women Voters. Eric Cruz, Morales, New Jersey Alliance for Immigrants. And Peter Chen, Jersey Policy Perspectives. 3 minutes each, thank you.
Thank you, Senator.
Absolutely.
Hello, good morning, Chairman Zarlow, Vice Chair Greenstein, and members of the committee. My name is Melissa Marks, and I'm testifying on behalf of the League of Women Voters of New Jersey. We are here today to oppose S2930. This is about transparency. Our opposition is to the erosion of transparency that we see happening in this bill. Our core issues were not addressed in the conversations that were had or in the amendments, and we just saw the current version of the bill at the start of this hearing. So there were additional changes that were not sent and shared ahead of time. As a senior organizer, I have firsthand experience communicating with members of the public, your constituents, over the last couple of months that are outraged by this bill. For a brief yet powerful moment, the bill was pulled from the Assembly Appropriations Committee in March, and members, myself included, celebrated because democracy worked that day. Since then, members have expressed their concern that this bill will come back and be rushed through again, despite their continued public opposition. They have not had much time to review the amendments, especially the ones introduced today, and they continue to express their concerns with the direction that our democracy is going in New Jersey with bills like S2930. The amendments fail to address the League's core concerns with this legislation. There are too many components of this bill that will make it harder for the public to access public records. One of the areas that is most troubling to us and to many of our partners, as you've heard already today and will continue to hear, is the guts to fee shifting. We have made it clear that fee shifting needs to stay strongly intact for the protection of New Jersey's Open Public Records Act. Without fee shifting, regular members of the public will not be able to access legal representation when records are improperly denied, which we know does happen. It is a key component of transparency and access. We will not support a bill that erodes public access in this way. The bill creates additional and unnecessary hurdles for the public, including putting the burden on the public to prove that a fee from an agency is unreasonable, prohibiting the public from requesting records from multiple agencies, and asking for difficult levels of specificity in requests. What's worse is that the public continues to face vague and unclear threats of lawsuits. Ultimately, members of the public will be less likely to request the public records that they are entitled to, and if they do make those requests and they are wrongfully denied, they will have less ability to pursue legal action. So S2930 also does not accomplish its stated purpose of modernizing the Open Public Records Act. This bill falls short of introducing changes that would improve OPRA to make it more efficient to access public records, to help understand government accountability and hold government accountable. I urge you to stand up for democracy and vote no today. Thank you for your consideration.
Good morning, members of the committee. Good morning, Chairman Sarlo. My name is Eric. I'm the Policy and Advocacy Manager at the New Jersey Alliance for Immigrant Justice. This testimony is submitted on behalf of the Alliance, together with over 50 member organization, NJAIJ fight for policies that empower and protect New Jersey's immigrant communities. I'd like to start by saying that it would be impossible to fulfill our organizational mission without a strong, fully accessible, transparent, and timely Open Public Records Act. NJAIJ and other advocates rely on public records to ensure that our communities' rights are upheld and that we receive a fair share of resources, of services and programs. We have worked with the legislature to secure major wins for immigrant communities, including driver's licenses for all, a ban on local contracts for federal immigration detention, and the state's first ever language access plan. Without OPRA, NJAIJ and our members would not have been able to find information about immigration and customs enforcement agreements with law enforcement, ICE detention contracts with counties and private prisons in New Jersey, language barriers at state agencies who provide direct services to the public, language access for officials, state announcements including emergency declaration and public health announcement for COVID-19, and so much more. New Jersey's OPRA law is a cornerstone of our democracy, and Bill S2930 84045 undermines the work that we have done with this legislature to ensure that communities have access to information, resources, programs, and the rights that we have fought so hard to win. We should be working to increase government transparency, accountability, but this bill does the opposite. NJAIJ opposes Bill S2930 and urge you to vote no. These new provisions that have been added to the bill do not intend to do that and do not intend to modernize OPRA. Thank you for the opportunity to submit testimony.
Thank you.
Morning, Chair. Morning, members of the committee. Thank you so much for allowing us to testify today. I'm Peter Chen, Senior Policy Analyst at New Jersey Policy Protective. We're a think tank based in Trenton that focuses primarily on tax and budget issues, but also on social economic justice. So I have written testimony which I've submitted, but I'd like to focus on a requester, okay? Like what a member of the public will have to go through now under the amendments under the bill that's proposed, that would be hurdles to getting the information that's necessary. And we as an organization, we file open requests for a wide range of issues, and they're often an important tool to get information about how government is operating. Is the government using public funds in a way that's responsible? So if I'm a member of the public, I file an open request, I have to use now a specific form, right? I have to go through a specific method of doing so. And now, under this bill, I also have to specify what I'm looking for with a strong degree of specificity, right? Who is this? What person? What position are they in? You've seen the org charts at a lot of state departments. There's lots of blanks on there. Who am I supposed to be requesting emails about? I might not know, right? Then, on top of that, email logs, call logs. There's more restrictions placed on these kinds of metadata that are necessary to identify who it is I'm supposed to be asking for, right? This is like you go to the store, you don't know who to ask for to get help. And in this situation, the member of the public is in the dark, So now, let's say they actually get a response. Oh, okay, this is going to be a $1,000 fee. Well, why? Well, it's reasonable. Here's the reason. It's presumed to be reasonable. Now, that's another obstacle for a member of the public to try to get this information. So on and on through the bill. We could go through item by item, through the amendments, and going all the way to the fee shifting, which is, okay, if you get denied, what's your recourse? You know, there's not exactly a ton of lawyers who are going to take these cases. So all the way down the line, we're thinking about something like the force report. This is something that NJ.com produced a number of years ago. It involved finding out what the use of force policies and instances of use of force were in law enforcement agencies across the state. It required hundreds of open records requests to every municipality, county, and law enforcement agency in the state. And if even some of those came back as denials, and there was no fee shifting available, or if the custodians said, oh, this is going to be $1,000, $2,000 in order to produce, that would have put a huge stop to a major piece of investigative work that ended up triggering substantial policy change at the state level and shed light on an area where we did not have information. So the last point I'll make is, your Senate Budget Committee, frequently you are asking the executive branch and its departments for information about its budgets, about how they're spending their money, about which people are allocated to what, about certain contracts. And frequently you have expressed displeasure or annoyance at the vagueness or lack of information in some of the responses. Now put yourself in the position of the public, who has none of the resources available to the legislature to ask those kinds of questions, and see whether these kinds of obstacles, the fees, the potential threat of litigation, the hiding of certain kinds of information behind closed doors, ask yourself whether that would increase transparency or whether that would make government more closed off and less accountable to the public. Thank you.
Thank you. Thank you. Thank you, folks. Who's representing Rutgers AQ? Do we have the one individual? Okay, please come on up. Addition, C.J. Griffin, representing Ashman Stein. And Assaulted Thomas, Institute for Social Justice. Rebecca?
Yes. My name is Rebecca Given. I'm an associate professor of Rutgers on the New Brunswick campus, and I'm general vice president of Rutgers AUP AFT. We represent scholars and researchers who work in public higher education because we believe in public higher education, which means we believe in democracy. We use public records in our research, in our scholarship. We also use public records to hold Rutgers accountable, and we use public records as members of our communities. Without the fee shifting provisions, the original fee shifting provisions, not the newly proposed in amendments which we received around 10 a.m. this morning, we could not have successfully sued Rutgers for illegally denying access to records. Our lawsuit exposed questionable financial practices where millions in supposed internal loans to athletics were magically booked as revenue to athletics, obscuring the size of the massive subsidy to athletics. Our members believe in democracy. I should not have to be here. We should not have to be here fighting for democracy on an issue as basic as this. Higher education and democracy are under attack. We should be increasing democracy, not undermining it. The amendments do not go far enough. This bill is fatally flawed. We appreciate the opportunity to make some improvements, and I want to acknowledge that. We did engage in a dialogue, and there are improvements to the bill that are initially compared to how it was initially proposed, but these changes do not go far enough. The fee shifting provision is a huge problem. It would diminish our ability to hold Rutgers University accountable. I think probably everybody in this room has a connection to Rutgers University and wants it to be a transparent, shining star of a public institution, and we need to be able to hold institutions like Rutgers, as well as other government entities, accountable. Anyone who votes for this bill as written is voting to diminish democracy, and we'll remember that.
Folks, please, we understand you're all in favor of the bill. We don't need, if we we can just avoid the clapping. We typically do not have that. Please, let's be respectful. People on both sides of the issue, please. Thank you.
There you go.
Hi, I'm CJ Griffin. I'm not representing my law firm. I'm here in my personal capacity. I would encourage you to ask questions because we want to hear what your questions about the bill are, and that's the best way for us to address it. But I will start speaking. I will first say these are public records. What that means is they belong to the public, and the agencies that are holding them are custodians. That's important to remember. Our taxpayers pay those custodians. Our taxpayers paid for all those records to be created. We deserve access to the records. The question that was presented in the poll is fair. This bill does nothing but restrict access to records and place hurdles that make it harder to request them.
What amendment you're focusing on?
Every amendment in the bill. There's not a positive amendment. I want to talk two things. One, the mayors are still up here talking about commercial requests. That charade is gone. It's not. This bill actually gives commercial requesters a preference that I'm sure every member of the media would love to have. Before the bills ban data brokers, that farce is gone. Data brokers can now use overhaul they want. Commercial requesters, it says they can now take 14 days to fulfill a request. I ask all of you to go fulfill a request and file a request in a random town. You're going to find almost everybody responds asking for an extension. It's very hard to get records in 14 days, let alone a month, let alone 2 months. So giving commercial requesters this 14-day extension for clerks to use is not a real change in the status quo. But the bill does something now in the amendments. It says, well, the commercial requester can pay to get a response in 7 days. The media can't pay to get a response in 7 days. They would love it. It takes a month, 2 months, 3 months to get a simple contract about the FIFA arrangement. If your goal is to handle commercial requests, most of which I think are really requests by realtors asking for records about property purchases, but if your goal is to handle that, and I understand that concern, it's a problem, this bill doesn't do it. This bill instead guts transparency. So now I want to go to the fee shifting, because everybody wants to paint this as just attorneys caring about money, and it's a cottage industry. Unfortunately, when you're an attorney that represents people that can't afford to pay attorneys, you get labeled negative names. One is a cottage industry. Senator Scutari has probably been called an ambulance chaser because he represents people in contingencies for personal injury. It's an insult. But what you do is when you represent people in civil rights cases, you're representing people that can't afford to pay. And in this world of OPRA, there's no damage claim. So the only ability to represent people, because you can't take a percentage of the damage, all a requester gets is a record. The only way to be able to represent them is for them to be able to pay. Most people can't afford to pay the $300 filing fee, or to have a fee shifting provision. And what the fee shifting provision means is that I can get a case and I can say, I think I can win it. I feel pretty confident, but I'm going to take a risk that I can't. Oh, okay. So let me just say, this bill does, and someone please ask me questions about this. This bill guts the fee shifting in a poor way. By saying may versus shall, it seems simple. But the public policy in general is that you don't get fees. And so courts apply that. So when they see may, that means you generally aren't going to get fees except in extreme circumstances. And then this says you only get fees, shall get fees if there's bad faith or knowing and willful violation. Courts don't like to find anyone, especially public servants, in bad faith. They don't like to say lawyers who are knowing and willful or acting in bad faith. And then there's one more provision that no one's talked about, but it's important. And it comes up a lot, which is maybe this week you saw the New Brunswick Today video where we obtained videos of police officers escorting the migrants who were delivered to the New Jersey Transit train station. And the video at the end, the cops make these really offensive statements. Well, they denied access to that video. I felt that we should get it. Let me tell you why. No. So we sued, because I'm talking about the amendment. We sued, and they, thankfully, Senator Coughlin, or Assembly Speaker Coughlin's firm represents them. Once they received the lawsuit, they produced the videos, and now it's out there that these cops said these terrible things. But this bill means it has this language that says if the agency receives the lawsuit and gives you the records in 7 days, you have to dismiss your complaint. And you only get fees if you prove
that they knew or
CJ.
should have known that it was a violation of law.
Thank you. I know you said you wanted 2 questions. I'll give you 3 quick questions. I know you represent a lot of folks in this area of law. When you go, you represent yourself or you represent Pashman Stein in court?
I'm an attorney at Pashman Stein. I represent clients, so I represent
On behalf
the
of
media.
Pashman Stein?
Yeah, I'm an attorney. Yes.
Okay. We had in one of the amendments that I was very interested in, it was a $300 cap. Would that go back to the original language of shall $300 cap? Would that work for you?
Will you let me answer the question in full? Because you
I'm
weren't letting me
answering
finish. So
it.
here's, I want to explain.
Yes or no? It's a yes or no.
I want to explain why.
No, just a yes or no. It's $300.
I want to explain why.
Okay.
Because you don't understand, Senator, you don't understand how fee shifting works. So here's what happens.
Let the women speak, like you let the men.
So when there's an OPRA case, the public agency's attorney gets 100% of it, every single minute they bill, they get 100% of what they do. The requester's attorney only gets paid if they win, and then once you get paid, say the cap is $300, okay? What happens is, so say I spent 10 hours at $300, then it either is going to be negotiated, and a mandatory fee shift means the agency is incentivized to settle it, because there's no argument. They have to pay us, so why go through another round of briefing and court argument? So that saves the agency money, because they're not paying their attorney to argue over whether we get it. So, say $300 at 10 hours, that's $3,000. So then the agency attorney and I will often say, okay, what about $2,000? I say $2,500 a deal. So right there, that brings the effective rate to $250. But if you go to court, then the court's going to say, okay, 300 is the cap, but I only think that's going to be $250, and I'm also going to only do 5 hours. And I can say, well, you know, the agency attorney spent 12. So you understand.
I understand. Thank
The
you.
effective rate will always be
The
less.
legislation, this is not a question, it's a statement, so you don't need to comment. The statement was, we have proposed $300, and many advocacy groups came back and had indicated to us that that would not work for their attorneys, the $300 cap. That was automatic. You get paid $300 regardless, $300.
It's because the effective rate would never be $300.
My final question is, and I'm not an attorney, but I do know the answer to this. In many instances, have you received in excess of $500 an hour? In some instances, you requested $900 an hour on behalf of your clients.
I have never requested $900 an hour.
Have you requested in excess of $500 an hour?
In court? No, I think my max request or the amount I've received is $525 an hour, but again, the effective rate is less.
Have you ever requested a $525 an hour plus a 50% enhancement fee?
I don't recall, but let me tell you what an enhancement is. It's for a very risky case, when you have to go, for example, all the way to the Supreme Court.
Thank you. We have just some municipalities have provided us where you have 50.
But it's misleading to suggest that that's normal. It's misleading to suggest that we even received it. I think I've only received a fee application once, and it's when Judge Jacobson, the nicest judge on earth, called the Department of Health the poster child for how not to handle OPRA.
Thank you.
I'll just add that we're in support of mandatory fee shifting, and the fees are already required to be reasonable, so this is covered.
Okay.
And we only receive fees if we win.
Any questions?
No.
You have a question, Senator?
Just somewhat related to this, thank you. So, if I understand this correctly, there's also a change, when we're talking about fee shifting, about when there's a question about it, of who's presumptively responsible. So it is changing it from the agency to the requester. So can you just talk about that amendment piece of it as well?
Are you talking about the service charge? I'm sorry,
No,
or the attorney's fee?
I'm talking about the burden-approved fees or service charges are reasonable. There is, if I understand the amendments correctly, there's a change in who is responsible for proving reasonableness.
So that's about a service charge. So there's two ways, there's a key way that agencies will often deny access to a record, and they'll say you have to pay a service charge. So, and this comes up a lot in the world of police body camera footage. The police often don't want those videos to be released, and so they will say, you could have this, but it's going to take us 8 hours to review it, and so that's a $3,000 fee. Well, the media and no one else can afford to pay $3,000. So right now we can go to court and we can argue to the judge that that fee is unreasonable. And the judge will look at the video and say, it shouldn't take you 8 hours to do this, I'm sorry. Or I've had I've had agencies try to charge $200 to take a screenshot, things like that, and we've gone to court and the judge will say that fee's not reasonable. This flips the burden. So in every OPRA case, the agency has the burden. So they have to go to court. They have the burden because they know everything about it. They know what videos exist, how long the videos are, what technology they have. So they have to go to court and tell the court all the information to try to prove they're right. This flips the burden and says somehow we have to go to court, which we couldn't do because we don't have mandatory fee shifting. We have to go to court and somehow convince the judge that it's unreasonable when we don't have access to any of that information. We don't know how many videos there are, we don't know their technology, anything else. So assuming that someone is willing to take a huge risk on a case that you wouldn't get fees, and they do take the case, then you're gonna have to go in and say, well, I'm gonna have to have an expert and a deposition and all sorts of things to try to prove that the fee is unreasonable because I have the burden of proof. So an OPRA case becomes more expensive, but most likely what will happen is people are just gonna receive these fees and there's no way to push back. And so it's just, like many other provisions in the bill, a way to deny access without expressly being honest and saying we're just denying access.
Thank you. Thank you to the panel. Next up is going to be John Donadio, representing New Jersey Association of Counties. Michelle Papa. Oh, they're right on here. John Donadio, New Jersey Association of Counties. John Burns, New Jersey School Board Association. Lori Buckle, New Jersey League of Municipalities. All in favor?
Good morning, my name is Lori Buckle. I'm here on behalf of the officers in the Executive Board of the New Jersey League of Municipalities to express strong support of S 2930, which makes various reforms to the Open Public Records Act. The League and our members strongly believe in an open and transparent government, as you heard from the mayors that previously testified. And we strongly believe residents must be informed on the workings of government to participate in democracy. At the same time, we must protect taxpayer dollars from the abuses we have experienced under OPRA. The amendments in S 2930 are a positive step forward to modernize and reform OPRA. As amended, the legislation effectively addresses privacy issues, makes it easier for residents to access government records, defines commercial requests, streamlines the administrative process for records custody while maintaining access to records and transparency, and provides a long overdue level playing field regarding prevailing attorney fees. We have seen a lot of misconception and misinformation about the legislation since its introduction. The bill will not hinder a resident or news reporter from using OPRA to get access to public records. Under this bill, if a resident submits an OPRA request for emails between the construction official and code enforcement officer regarding property violations, they will get the record if the record exists. Under this bill, if a news reporter submits an OPRA request for a copy of a professional service contract, the reporter will receive a copy of that professional service contract. The bill addresses the burdensome commercial requests that continue to increase year over year. Since the enactment of OPRA, commercial enterprises have abused the legislation as a mechanism for commercial purposes. Their actions cost the businesses themselves little to nothing, but the public entity expends resources and response efforts. Therefore, transforming OPRA into a commercial tool was never intended to become. Again, under the bill, the resident and the press, who are exempt from the definition of commercial requests, by the way, are still able to access government records. What would stop is residents receiving unsolicited solicitation from commercial enterprises. Before I wrap up, I do want to address some of the issues we've heard so far this morning. We've heard a lot on personal identifying information. I would point out that the changes in S 2930 are the recommendations that the Privacy Study Commission recommended in 2004 that were never implemented. And when we speak of personal identifying information, it is referring to personal email addresses, bank accounts, credit card and debit card numbers, and home addresses of our residents. You will still be able to access government officials' official information, you just won't be able to access your neighbor down the street, their personal identifying information. And again, that was a recommendation of the Privacy Study Commission, which came out when OPRA was initially signed because the legislature at that time realized they did not have time to address privacy, created a study commission, and this is implementing this recommendation. I would also like to note that you can still get emergency notices under this bill, but you just would not be able to get the list of residents who signed up to be on that emergency list. I thank you for your time, and we thank you for your support.
Under these amendments, under these amendments, municipalities would not have to release the ages of minors on a recreation list, correct?
Correct, that's also in there, which was a recommendation of the Privacy Study Commission for those under 18.
Okay, thank you.
Good morning, John Burns from New Jersey School Boards Association. From the School Boards Association's perspective, there are two things that this bill does in a very positive way. First, it clarifies the information that an agency must protect with regard to both the requester and also the citizen with regard to the information that it has. Every agency, whether it's a school district or a municipality, every day they deal in vast quantities of personal information. This bill clarifies that an agency has a duty to protect certain personal identifying information, to protect those citizens from the release of that information. The second thing that this bill does, which is a positive, is that it modernizes the way in which records custodians can fulfill records requests. The amendments to the bill say that the requester can fulfill a records request by pointing to the space on the agency website where that record can be found. This helps with regard to the efficient administration of OPRA requests and gives citizens the opportunity to get access to the information that they're requesting in a quicker and a more efficient manner. And so, because of those improvements, the New Jersey School Boards Association will be supporting the bill. Thank you.
Good morning, Mr. Chairman and members of the committee. John Donadio with the New Jersey Association of Counties. For the reasons set forth by John and Lori, we support the bill as well, but we also support the legislation because it controls attempts to mitigate excessive attorney fees. And Mr. Chairman, you correctly pointed out that plaintiff attorneys regularly ask and receive well over $500 an hour, in excess $560, $575 an hour to litigate these matters. We have one recent affidavit of services at $250,000 to litigate an OPRA request. And if you go to the $565 an hour, I did the math. If you work 35 hours a week, 50 hours and 50 weeks per year, that's almost $1 million a year in salary. I mean, it's just mind-boggling to me, and I can't believe that the initial legislators who introduced this bill contemplated attorneys making, that type of money to litigate OPRA matters. I can tell you, and you were also correct, Mr. Chairman, in pointing out that county councils at the county level, many of them handle OPRA matters. They earn maybe between $80,000 a year to $200 and change $1,000 a year. But other counties use outside counsel, and you were correct in pointing out that it's about $180 to $200 is the average that they use outside counsels to litigate OPRA matters. Something has to give, and although we certainly support the amendments on the fee shifting piece of it, we would say that it should go further and have the may and place a cap. And I think $300 is a reasonable cap. We thought maybe $200 or $250 an hour, or make it similar to what local governments pay their outside counsels. But one of the things that we heard, well, it's not a significant amount of money. $225,000 is not a significant amount of money. But from where we sit, All right, it's death by 1,000 cuts. It's just not OPRA excessive attorney fees and OPRA requests. It's health benefit expenses, it's pension expenses, it's the cost of goods and services. Again, it's death by 1,000 cuts. And something has to give, and I think this legislation, with respect to how it addresses attorney fees, is a very good step. So we support the bill, and thank you, Mr. Chairman, for your work on this bill. We appreciate it.
Thank you. Thank you to the panel. Any questions from the panel? Senator Zwicker. You go first. And Senator Scanlon.
Thank you to any of you. So we heard from the mayors previously that, they're talking about statistics in the last days or a week or so, that there were very few OPRA requests coming from citizens. But then they said sort of a list of where else they were coming from. We heard from Rutgers that it's often a tool that is used in research, and not just Rutgers, from others. How do you know what is this commercial request that's a burden versus what is a legitimate request in just public record access?
If I may, I would just point out in the definition of commercial, news organization and research and scholarly institutes are exempt from the definition of a commercial purpose.
How would you know?
Well, because when you fill out the OPRA request, you would identify who you're with, and if you say you're with Rutgers University, the custodian will see that it's a scholarly institute and not a commercial purpose.
So I think too, if you don't mind, I think the bill attempts to address that. The amendments to the bill attempts to address the commercial request, but I think what you're asking is how now do the mayors or the county officials identify whether or not it's a commercial request? And many of the counties have, if I'm just guessing what your question was, there's a software that many of them use. And if it's a citizen that comes in and records that accordingly, and I can share you an Excel spreadsheet that one of our counties shared with us that provided a listing of all the different commercial requests that they received over the course of the year. So they're able to differentiate between the citizen coming in, the press coming in, et cetera. Some counties maybe not, they don't use that software, but most of them do, and they can make that distinction.
Thank you. Senator Scanlon?
Just real quick, we've heard conflicting contentions about whether the bill, as amended, actually does solve the commercial or data broker issue. You're under the impression that it still does? That's to anyone?
Well, it provides relief. Obviously, we would have loved the bill to go much further, but as Senator Starlow stated at the beginning, there is compromise. So we do believe it does provide some relief because it does prohibit the release of certain lists that are valuable to the commercial requesters, such as your permits, your animal registration and such. So it's a step in the right direction.
Okay. John, that $250,000 fee that you talked about, that was awarded?
That was requested, and I believe it was rewarded. Yes, sir. And I can share you the affidavit of service. I'm happy to do that.
Well, it sounds like a pretty outrageous fee, but also, if it was awarded, the courts found that the claim was legit, and maybe that entity should have settled before they got to that point. One could argue, but it does sound like an excessive fee. I agree. I'm not, without commenting on how long it might have gone on for. How about the issue we heard about this morning, that the burden of proof shifting to the requester about the appropriateness of the fee? That seems like a legitimate concern to me. It's not?
Can you clarify the question?
This scenario was a request about, I think, police records or video, and the agency saying it's some outrageous level of fee and it's a burden to produce it. The burden apparently now falls on the agency to demonstrate the validity of that claim. Under this bill, the claim this morning, I haven't read it specifically as far as this goes, but that burden would shift to the requester, and they don't have access to make the argument that it's inappropriate. If you haven't dived into the details of the bill either.
Yeah, I'd like to look at that closer and get back to you, but I think you're talking about the rebuttable presumption that now the local requesters have. Yeah, I think I'd like to get back to you, to be honest with you, on that particular piece of it. Unless, Laura, you can elaborate.
I would, like John said, to go into a little further, but I will point out that right now to do a special service charge, municipalities have to adopt an ordinance in advance. So in order to adopt an ordinance in advance, you have to anticipate what all your special charges may be and not be able to anticipate what type of charges. And with police records, that's one of the areas we were disappointed to see that the study on the police records was taken out, because police records are one of the areas that our towns are receiving a lot of requests on, and it's important to note that we're being told by police if there's 1 hour body camera footage that's taken police 3 hours to review, to go through, to make sure it's appropriately redacted. So if you have a scene where 5 police officers show up and you have 1 hour worth of body camera, that's actually 15 hours worth of work to go through each police officer's camera and appropriately redact information.
But doesn't that kind of lend some credibility to the claim that some of that information the requester wouldn't have? They don't know how many police responded. So if there's a huge fee that's proposed and the requester has to challenge it without the knowledge of how many, it seems to me that the burden should be on the agency rather than the requester, no?
I think the agency has a responsibility to let the requester know, listen, it's going to take us X number of hours to go through, and this is the cost.
Okay. All right, thank you.
Thank you. Thank you, panel. Well, I want to acknowledge Senator Luca, who was very adamant that amendments be made about excluding the intimate body parts that are now being requested and published online. So I really give Senator Bucco a lot of credit for that, for his efforts. Okay, we're going to continue, 3 minutes each. Marcella Simidoris, POP, April Nicholas, Tara Astor. 3 minutes. Folks, we still have about 20 people to go here. So 3 minutes each. I think we're going to sit back a little bit, listen now, and yeah, we'll go from my right to your left.
Praise the Lord. Marcella Simidoris. I'm an educator and a parent. I'm speaking today on behalf of POP. Dear Senator Paul A. Serlo, Chair, and Senator Linda R. Greenstein, Vice Chair of the Senate Budget and Appropriations Committee, and other members of the 221st New Jersey Legislature. The People's Organization for Progress, a long-standing grassroots organization fighting for racial, social, and economic justice and peace, opposes the bill S-2930 and says vote no. The way in which it is currently written with amendments, this bill undermines our democratic right to have a governmental transparency in providing access to public records. We do not want any of the provisions of the Open Public Records Act gutted. Given the current state of affairs, we deem this legislation extremely undemocratic and flawed, putting additional financial burdens on people wanting to access public records. Given the continued overwhelming financial burdens on individuals and community groups superimposed by the pandemic added to the everyday monetary challenges, this would additionally impact individuals appealing improper record requests, continuing transparency and accountability to which we are all entitled. Instead of directly challenging our democratic right to access public records, i.e. police brutality video recordings and other records tied to police misconduct and other entities that are expected to be accountable to the citizens of New Jersey, we would expect you to only support a process where the public interests are at the forefront. POP is always open to improving systems, but not at the public expense where it undermines the very fabric of democracy. Given the many tenets of our governmental agencies that are responsible to meeting the fundamental needs of its citizens, including but not limited to transparency and accountability, we would encourage New Jersey establishing a Sunshine Law Commission. In this process, we would expect participation in its development to include not only legislators, but large community representation to ensure that concerns and needs are greatly represented. And Chair Sarlo, I just want you to know, as an organization, we do a lot of work in holding our agencies accountable. The Department of Education is one of them. And I would just like to go over a recent OPRA request that I put in where I had some correspondence with the record custodian. My request was asking for the usage report of seclusion classes in Montclair Public Schools, because they throw little kids into padded rooms in Montclair Public Schools, and they asked me to specify. She said, "We are on receipt of your request. Could you please clarify what you mean by usage reports so that we may continue to process your request?" And I said, "The reports that indicate when children have been put into seclusion closets or restraint." I got it back denied or not made and maintained. So this is something that I've actually submitted over 300 requests to the TOE as a citizen, and a lot of them are denied, and a lot of them I know I could fight. So with regards to where the School Board Association is coming from, I just want everybody to be mindful, they do not represent children, they represent school boards, which sometimes are a barrier to equity in my experience as a teacher for 24 years and a parent in Montclair. Thank you.
Thank you.
Hello, my name is April Nicklaus. I'm here today as a concerned citizen who has utilized the Open Public Records Act multiple times and whose ability to engage in civic life has been greatly enhanced by the hard work of news organizations who are able to bring the public high-quality, fact-based, and enlightening news coverage, thanks largely to their ability to access public records and to fight for their rights and ours when access to those critical public records are unfairly refused. Several amendments in this bill are of particularly high concern to me as a citizen. First and foremost, it allows municipalities to sue citizens who they feel are improperly utilizing this right. And I feel that you can't rightly claim that the public has the freedom to access public records while at the same time imposing a looming threat of retribution for people who dare to use that right. I also want to note that gutting the Open Public Records Act provision for fee shifting effectively prevents average citizens from fighting for their rights when they have a reason to feel that their requests have been unjustly denied. What this amendment says to the public, essentially, is that you can only fight for your rights in the legal system if you are 100% confident that your own independent wealth or access to special resources allows you to take on that fight. Gutting the fee shifting provision in the Open Public Records Act will, in practice, chill public ability to fight for their rights to access public information that has been unreasonably denied to them. Another amendment of concern is the restriction on requesters being able to submit a request to multiple agencies. It's often necessary for a requester to seek information from multiple sources in order to actually get that information in a timely manner from any of those sources. And this amendment seems to me a prime example of an amendment that restricts a citizen's ability to access information and makes it easier to deny requests without any clear reason why. And that is what I have. Thank you.
Thank you.
Hi, my name is Tara Astor. I came here as a resident, but I am also a councilwoman in Mount Holly in Burlington County. So I will speak as a resident, but also as an elected official. I did have an opportunity to read the amendments about 20 minutes ago, and when I filled out the slip, it asked me which bill I wanted to speak about, which was S2930-1R by Salo and Muko. It did not ask me about specific amendments, but luckily I've heard everyone else speak, so I've had an opportunity to figure out which specific amendments I want to address. So I am a councilwoman, as I said. This bill would make changes to the process for the access of government records. In my opinion, honest communication and transparency are the foundation of a healthy democracy. Is actually what I ran on as a councilwoman. Making it more difficult for people to get access to government records would only make the public less trusting of their government. We should be moving in the opposite direction of where we're going. We should be working to have more transparency and to get the public to trust their government more. As an elected official, I'm aware that anything that I communicate in a township email is subject to OPRA, and I have nothing to hide. If I weren't comfortable with the public knowing what's in my township communications, I'd certainly be doing something wrong. Now, in regards to personal information, I'm absolutely 100% supportive of protecting my personal information about my family, about minor children. It's the fee shifting, specifically or punishing people for making multiple requests. Those are the two issues within these amendments that deeply concern me. In my community, my local residents' OPRA requests have helped me to be informed when particular information that should have been shared with me as a councilwoman, I actually found out by one of my residents doing an OPRA request. And not a lot of people know how to do OPRA requests, and making it more complicated and asking for more specificity would only make it more difficult. And I know a handful of people that are very good at doing OPRA requests, and I think they should just teach classes. But those OPRA requests gave me information of things that were going on in my township that I didn't know about, that helped me to be a better advocate for my residents and a better councilwoman. Because sometimes, people don't always share information. So I continue on, I add them to sort of tie it all in with the amendments. I don't want to make it more difficult for people to know the truth. And I certainly don't want to punish people financially by asking too many times, especially when so few people in my community know how to do an OPRA properly. And also just, the fee shifting, it's just anything where it is cost prohibitive, I'm against. I support working people, working class people. There are a lot of people that will be here today that aren't because they're out doing their jobs, running things. I know that to have the liberty to adjust our schedules for self-employed, but we're able to be here. I'm wrapping it up. So in the end, our form of government is supposed to be by the people and for the people. And the Open Public Records Act, as it exists now, helps to keep that reality. I am totally supportive of any amendment that protects my privacy as a private individual. But what I do as a public official, the public should know. That's it. Thank you.
Thank you very much. Next, we're going to bring up a panel of people in support of the bill. Scott Campbell, NASW, social workers. Jacob Kaplan, Access New Jersey. If you can all come up at the same time. Michelle, I think it's Bobrowski, President of the Municipal Clerks Association, and Kim Marie White, East Hampton Municipal Clerk. And if you folks would like to begin, that's great. Thank you. Is everybody here from that group? Start on the right side.
Good evening. Thank you very much for allowing me to speak today. Thank you. Okay, here we go. Thank you very much for allowing me to speak. I think a lot of people have not talked about the most important issue is the personal identifiable information. There's a technical thing with the amendments. You got a definition, personal identifiable information, but the rest of the bill says personal information. That's not going to work. You need to change or actually strike out personal information and insert personal identifiable information. The other thing too is we'd like to make an amendment that when it comes to persons acting on a request of OPRA, we need to eliminate all personal identifiers. If we're going to lay out the landscape of more transparency, which I support, we have to protect the public, just like Daniel's law protects judges with their personal information. We need to pass that on to the rest of the public. So with that, I'm asking if you can amend that it includes names, specifically names and police records, all names. I know there's a tradition with police blogs releasing names. We've got to get rid of that because if we're going to lay out more transparency, we've got to eliminate the bad actors that use it for identity theft, for harassment, weaponization. That's happening. I mean, all this is on the internet. I mean, I could take any of your names, process it on the internet, find out exactly where you live, who your children are, And all that to say, that's not very comforting. So the most important thing about this bill is personal identifiable information. So my 2 amendments, I urge you, please vote in favor of this bill, and thank you for hearing me today.
Can I just ask, I'm sorry, what is your name?
Scott Campbell.
You're Scott.
Thank you.
Thank you. Scott? Jacob, okay.
It's okay, I can call Josh more times than I can count. So thank you, Chairman Sarlo, and the other members of the committee for allowing me to testify today. My name is Jacob Kaplan. I am the Director of Advocacy and Government Affairs for Access New Jersey. We support the effort to modernize and improve transparency of public government records. Our organization has the honor of serving as the central nonprofit agency for the State Disability Set-Aside program that enables the employment of nearly 2,000 individuals throughout the state of New Jersey, working nearly 650,000 man-hours a year, earning an average wage of $16.45 per hour. And the amendment that we are particularly glad to see included is the exclusion of nonprofits from the requirements under the commercial purposes language in the legislation. Access New Jersey and all of our nearly 40 members are nonprofit entities, and we use the OPRA system to determine opportunities for individuals with disabilities to work on state contracts, everything from cleaning this building we're sitting in today, to document imaging and destruction, janitors, porters, you name it, our members and the individuals with disabilities that they work with do these jobs for the state of New Jersey. And we are glad to see that this language was included in the amendments in order to avoid any unintended consequences for a program that brings the dignity of work and good, honest wages to so many disabled New Jerseyans. So we encourage that you include that language, continue to support that language, and keep in mind the nonprofit community and workers with disabilities as we continue to go through the process of advancing this legislation. So thank you so much for your time today, and please, if you have any questions, I'm happy to answer.
Thank you. Our clerk friend.
Hello there. I'm Michelle Browski, President of the Municipal Clerk Association. As President of the Municipal Clerk Association of New Jersey, in regard to the OPRA Reform Bill S2930A4045, I want to extend my appreciation to all of you for your hard work, diligence, and dedication on overhauling OPRA through this bill and its amendments. As a 501c3, the MCA&J is a private, nonprofit organization that is devoted to supporting and advancing its members' educational, professional, and personal interests. The municipal clerks who make up the MCA&J membership serve with distinction on the front lines of public service as they assist residents in assessing local government services and information. As a general rule, MCA&J does not lobby or engage in partisan activities. That is intentional and reflects that municipal clerks are involved in activities such as election and licensing that require the utmost integrity and independence to ensure public confidence. MCA&J fully supports the principal public policy foundation of OPRA, including transparency in local government and the right of residents to be fully informed about municipal operations. However, the law is regularly perverted in a manner that severely diminishes the noble purpose for which it was adopted. OPRA reform is essential to save the OPRA law from itself. As municipal clerks, what we in our association have brought forth to many of you over the last several years is our personal experiences and data from the municipal clerks who hold a unique position on the front line of handling OPRA. And I hope this has been an effective tool for you to convey the significant problems and abuses that occur when it comes to OPRA. Our association has been involved in a significant amicus brief in 2022 that has played a significant role for our association. It has been our frontline experiences that have brought us twice before the Supreme Court, and won because it's fact and data-driven based. And it's that experience that other organizations have asked us to share when it comes to them fighting OPRA as well. In New Jersey, the municipal clerk occupies one of the most important and exacting positions in municipal government. In many instances, it's the hub of municipal operation. The municipal clerk, by virtue of his or her position, serves as a liaison officer between the governing officials and the taxpayers, and between the executive and general body of municipal personnel. The municipal clerk is an important public relations figure in municipal personnel. We do not have 9-to-5 jobs. Many of us find ourselves working what feels 24 hours a day, 7 days a week to ensure our work gets done because of us being the hub of operation. The current OPRA reform bill and its amendments are not reinventing the wheel. It requests that have been sent to our state representatives since 2019 with the same needed reform, nor is it a cry from municipal employees who do not want to do our jobs. That could not be farther from the truth. As municipal employees, we develop community bonds with our residents by working on the front lines. We talk to them when they come into the office, ask how their family's doing, and catch up with them. If a resident is looking for a record pertaining to the township, we're going out of our way to get them that document. It's their document as a taxpayer. But when commercial entities are constantly emailing OPRA requests looking for the latest list for dogs licensed that month, in-ground pool permits issued, solar roof permits issued, it causes our residents to not want to license their dog, comply with permits, or interact with the township because they don't want that information released to the public. My own municipality will not acquire a reverse 911 system to alert residents of emergency situations because we would need to obtain their email addresses and phone numbers. We have resident email addresses and phone numbers. We get OPRA for that information. Some OPRA requesters abuse the expansive reach of OPRA. They seemingly act like sharks preying on the public and government records to mine data, target residents, especially underage and elderly people. My township is doing a disservice to our residents, but because of concerns about releasing information to a requester, it's for their safety and privacy that it's done. Please know that we're not asking for OPRA to be abolished or preventing one from obtaining records, but state representatives need to focus on the safety and the financial aspect of the taxpayer. We as municipal clerks see the day-to-day when it comes to OPRA, and know more than anyone when it comes to OPRA, how it impacts a municipality and the taxpayers. I encourage you to visit your local municipal office where you live, speak to the municipal employees, and hear from them directly about how they witness the abuse of OPRA and how OPRA reform and these amendments are much needed, especially in a modern world where so much can be placed on township websites for all to see with a click of a button from the comfort of their home. I would like to reiterate that this bill and the amendments is not impeding one from filing an OPRA or preventing one from getting the records they are requesting. This bill delivers much needed reform to allow OPRA to continue the way it was properly intended. Though the bill is not perfect, it's a step in the right direction, and we recognize that there can never be a one-size-fits-all when it comes to OPRA. I thank you for your time and consideration, and I hope you can see the positive impact to OPRA reform and these amendments for our municipalities and for the taxpayers of New Jersey, and not be in favor of allowing the abuses that have come with OPRA to continue. Thank you.
I'm going to give Kim Marie White now, East Hampton Municipal Clerk, who's on many Zoom calls with us throughout the process. Members, I've just given the two clerks a lot of latitude here because many municipal clerks wanted to come down. Instead of having them all come down representing some 500 municipalities, these two individuals are representing all the clerks in the state of New Jersey. So give you a little latitude. Thank you.
Thank you very much. Thanks for allowing me the opportunity to testify before you today. My name is Kim Marie White, and I hold several key positions in East Hampton Township, Burlington County. One, I'm the municipal clerk, I'm also the township manager, I'm the qualifying purchasing agent, and I'm also a local registrar. Additionally, I have the honor of serving as the president of the Burlington County Clerks Association for the past 12 years, and have previously held the position of the president of the Municipal Clerks Association of New Jersey, just as Michelle Kowalski. With over 3 decades of experience in municipal clerk's offices, I understand the significance of adhering to the state-required laws and fulfilling core duties as being a records custodian is a core duty of the municipal clerk under the law. In my capacity, I handle OPRA Public Records Request Acts meticulously, ensuring that each one is carefully reviewed and processed in compliance with legal regulations. Every request undergoes thorough scrutiny to ensure that the requested information is provided accurately and any necessary redactions are made. The time required to fulfill an OPRA request can vary depending on the complexity of it. One request does not always equal one record. Most OPRA requests are complex and receive input and the review of multiple departments. To address this workload efficiently, my office utilizes an OPRA portal system called Next Request based in San Francisco, California. This system allows requesters to submit their requests online, which are then processed through the portal. Various departments upload the required documents, which I review for accuracy and make any necessary redactions to them before releasing. While this software incurs the cost of $7,000 per year to my taxpayers, it has eliminated the need to hire additional personnel to manage the workload. But even with technology, the volume of OPRA requests has changed how I provide service to the public. I used to have an open door policy, but with the volume of OPRA requests we receive, and in order to ensure compliance, I have to set aside several hours a day behind closed doors to review the footage and redact what is necessary. I would also note that most of the OPRA requests we receive are not from residents, but from commercial entities. As amended, S-2930 will provide relief to the process and hopefully will allow the opportunity to go back to an open door policy for our residents. I would like to thank you for an avenue to address harassment that unfortunately has been experienced under OPRA. Unfortunately, municipal clerks have seen individuals use OPRA to harass or take advantage of a town. I would like to share a recent experience regarding an OPRA request that was submitted to multiple municipalities seeking detailed records spanning over the year of 2 years related to payments made to the MCA&J, the Municipal Clerks Association of New Jersey, and reimbursements for employee expenses associated with MCA&J membership and conference attendance. This request, seemingly prompted by the absence of a municipal clerk during the annual MCA&J conference, places an additional burden on municipal staff who are already dedicated to their education and professional development. It is crucial to acknowledge that invaluable education role fulfilled by MCA&J providing training and advocacy for municipal clerks and deputy clerks. The proposed amendment to the OPRA law represents a positive step forward, especially considering the technology advancements and legal changes over the last 22 years. By supporting this amended bill, we can ensure that municipal clerks can prioritize for their residents and their education endeavors without being burdened by the excessive administrative tasks. Thank you for considering my testimony. I urge you to support this important matters amendment to the OPRA Public Records Act law.
Thank you for your testimony to the clerks. I will say this, I've witnessed many clerks firsthand. When residents come in, I very rarely see them tell a resident, fill out an OPRA request. What do you need? What can we do to help you? Let's get you the information to get you on your way. And I know you were a former mayor, and I know they do it in your municipality. Clerks, and I know, John, you were a former mayor, right? Clerks are on the front lines and do everything they can to help their residents, so thank you. Thank you for your service.
Thank you.
Thank you, everybody. Thank you. Okay. Molly Cleary, David Pringle, Herb Torbaus, voter choice. Joe Johnson, ACLU. Dina Matola Jaworski, Jersey Citizen Action. Antoinette Miles, Jersey Working Families. Just make sure we have enough room for everybody. One second. Joe Johnson here? Oh, yeah, there you are, sir. Okay. Did I call anybody else yet? Hold on, let's just. Doug O'Malley? Doug? I've seen you earlier, Doug. Where are you at? Come on up, Doug. And I got one more spot here. Brian Everett. No particular order, folks. We're just okay. 3 minutes each, please. Thank you.
Okay. Mr. Chairman, members of the committee, I'm Tina Matola, Jaworska, I'm the Executive Director of New Jersey Citizen Action, and I just first off want to say that my organization opposes this bill strongly, and we did not have the opportunity to participate in an actual negotiation. We attended one meeting in which we laid out many concerns about the bill, and in fact, the top concerns we laid out, the core concerns that we laid out have become worse in this current version of the bill, these amendments. And also, I think we all understand that a negotiation is a two-way conversation, which is not what occurred. And while we were grateful for the opportunity to share our concerns, I do have to object to the characterization of us helping to shape this bill, because I do not think that we did do that. I want to just speak to the amendments. So first I want to say the amendments do nothing to deal with the concern that commercial entities are overusing the OPRA law. We heard a lot of testimony today from county and local folks about the volume of OPRA requests, and there are in some towns many commercial requests, but this bill and these amendments do nothing to deal with that. If anything, it actually encourages more because it allows commercial entities to pay a special fee and have expedited requests fulfilled. So I think on that front, I really hope we can stop talking about that, because that's not what this bill does. Secondly, on privacy, sure, there could be a balance there and maybe some changes that could be made. The law, that wasn't really the problem, and it's not something that really needs more solutions. In fact, the concerns around commercial use and privacy are really just sort of excuses for what this bill really does, which is in fact to actually gets in the way of public participation in their democracy by making it harder to request documents that the public is fully entitled to as taxpayers who pay for all of these government entities and their jobs and the work that they're doing and the programs that they're providing to the public. The folks that use OPRA, and we know this all, is advocates like my group, so we do take this personally, activists and media. And OPRA is used to advance social justice, civil rights, and to give sunshine to how our taxpayer dollars are using. OPRA is used for good reasons. We don't want to tamp down on those very folks that are using OPRA for those very reasons. I need to address now the key concerns that we had and whether or not the amendments do or don't address those concerns. So first on fee shifting, I really need to say that, well, first of all, I just need to say that the concerns we have and what we think this bill now does is targets the public. It targets people who need to be using OPRA to keep democracy healthy. So first on fee shifting, there is no data from the legislature about these fees. We hear a lot of anecdotes, but that's not the reality. The courts deal with this issue and very well. They tamp down on the fees. They both reduce the number of hours that lawyers can charge and the per hourly rate. And so our lawyers, the Weissman Group, Weissman & Mintz, and other public interest law firms like Appleseed have been clear that this is not a problem and that these lawyer fees are dealt with, and they're dealt with appropriately in the courts. There are no greedy lawyers that we have to go after, so we would urge you to not think of it that way. I do need to address this assertion that the advocates rejected the cap. The advocates clearly said that we are willing to have a conversation around fee shifting. We did not have a negotiation around fee shifting. We are happy to have one. What has happened is the fee shifting has gotten worse. It stayed, instead of becoming going back to a shall as it should be, the language, it stays as a may, and creates barriers to people being able to get lawyers to represent them. And so that is an issue that we are very happy to have meetings about. Number two, I do want to address the fact that the amendments continue to target the public in that they are a person requesting records can be sued. This can have such
chilling effect. I joke with Maura on our staff that, there are agencies that we do file a lot of requests with that might feel that we're disrupting them in some way, but that's not the point. The point is those records belong to us, and these agencies should not be viewing us as an annoyance to go after and sue. We cannot allow that to go forward. And just in general, I don't see the emergency and why the rush. You're not solving any problems with these amendments. Really, you're creating problems for the people who use this law for good reasons, and we should be upholding their participation in democracy, and I urge you to vote no today.
I gave you a lot of latitude, folks. 3
Thank
minutes,
you.
please.
Appreciate
Dave.
the latitude.
Folks, I'm going to hold everybody. I know a lot of you drinking. Please, 3 minutes. I'm gonna stop you because we're running late and we have IRAD coming in.
Thank you, Mr. Chairman. David Pringle, representing Empower New Jersey, the state's largest climate coalition. Over 100 community, labor, faith, and other groups focused on securing a thriving, squeaky clean, truly green economy to alleviate the climate crisis, promote justice and public health, and create better jobs than the current burning economy that's literally killing people and destroying property. A strong OPRA is critical to that effort. As such, we strongly oppose the bill as introduced in the latest amendments. We do not oppose reform. There is reporting requirements in the current bill. That's good. We think the concerns about excessive litigation is overblown, and those reports will prove that once they're done. Obviously, equipment needs to be modernized, or the bill needs to reflect that. The commercial and for-profit stuff should be addressed as well. Make no mistake, the fee shifting in this bill is opaque. It's not transparent. It will reduce transparency and undermine good public policy on every issue. It will result in more denials of public records, and it will result in less litigation. That's not more transparency. The deck is already stacked against the public seeking appropriate government records. The defense lawyers always get paid, typically hourly, whatever the result. If anything, they have an incentive to overbill and have more litigation because they get paid more. The courts have the authority when somebody is filing a frivolous lawsuit or whatever to penalize them. Alternatively, plaintiffs only get paid if they win. Contingency basis, not hourly. If they lose, they get nothing. It's real risk versus no risk. If government doesn't want to have to pay these fees, then guess what? Don't break the law. Don't deny requests. It's pretty simple. And again, the courts have oversight. They are making sure the fees are reasonable when they are paid, etc. We also are very concerned how the amendments have been characterized. They are not our amendments. The amendments are at minimum debatable. You know where we stand on them. Regardless, the core line in the sand on this for us is fee shifting, and the amendments do not reflect that. I am just wrapping up. It's kind of like a 5-year-old getting their hand caught in the cookie jar. You're caught, and you deny it, even though your hand is still in the cookie jar. That's what's going on with this legislation. So let's, I'm going to make one final statement. You gave lots of other people latitude, and I'm going to reserve 10 more seconds. U.S. Democrats and never Trump Republicans are fighting for democracy. And this bill undermines that effort, and it's led by New Jersey Democrats.
Yeah. That part.
Hello, Chair. Hello, members of the committee. My name is Molly Cleary. I'm the environmental advocate for Clean Water Action New Jersey. It's, I would say, a pleasure to be here today, but with OPRA on the table, it's frankly a disgrace. So one of the major things that Clean Water Action does is use OPRA to make sure that our EJ communities, our environmental justice communities, are properly advocated for. Just a few months back, our environmental justice organizer, X-Braithwaite, was here speaking on OPRA, saying how crucial it is for her to ensure that these communities that she's advocating for, that she's representing, are heard and they are able to see the records of what is actually going on in these communities. Because it's so often covered up. It's so often, as we will see, redacted. And that's part of the amendments that is just such a large issue. Having these guardrails on redaction, or lack thereof, guardrails are so important because when we have these these just vague comments on redaction, how are we supposed to actually ensure that people are being held properly accountable? And I hear the folks that are speaking about the custodians, and I hear them and I see them. There's $8 million appropriated in this bill. There is a chance and there's a suggestion that we would be able to reappropriate some of that money to create additional staff so that burden is lessened on our fearless and very important custodians of OPRA. Myself and Clean Water Action, along with the great advocates here today, are here speaking on behalf of the people that use it and need it. Thank you for your time.
Thank you. Joe, ACLU? You ready, sir?
Yeah, I'm gonna run my own time just so I can trust it.
Oh, Joe, come on.
It really is an honor today to be able to speak to a room full of 3 senators. It's great. I would like to start by addressing the same thing that you started with, Senator Sarlo. So being as you started by naming the ACLU of New Jersey as being part of the negotiations, let me be incredibly clear for the record. This is an awful bill, and the ACLU of New Jersey wholly condemns it in every form we've seen so far.
Yeah.
We appreciate both Seth and Tim for engaging us in these conversations, but when the sponsors and leadership will not allow them to make any of the major changes that we're suggesting, it's all meaningless negotiation just so you can claim that you worked with us. If I owned a house, I would have bet it all that you would have started this meeting by name-dropping us to try to add credibility to this terrible bill and terrible process, and I'd be much richer today for it. As it relates to Senator Sarlo claiming that this isn't about transparency, but instead attorney's fees, all I can say is that that is a bold-faced lie. If you trusted the lawmakers and New Jerseyans in the room to listen to the experts on the issue and make their own decisions, you wouldn't need to start with a 5-minute monologue to try and bias other people's opinions. Now on the bill, I'm quite confused here.
Hey, Joe, I've given you a lot of latitude, Joe, excuse me. I've given you a lot of latitude. Nobody has attacked anybody personally. You've now attacked many members up here personally. Okay, we haven't attacked anybody personally, okay? And you've been attacking people personally. It's disrespectful to the process. So, I just speak about the amendment, sir.
On the bill.
And I'll give you 10 seconds back for my monologue.
I am quite confused hearing government officials talk about this bill. Some say it's about modernization, which it doesn't do. Others say it's about addressing commercial requests and data brokers, which it doesn't do either. So what are we doing here? The legislature has told us for the past 6 months that this bill will focus on commercial requests. Yet here we are and the bill does nothing to address this issue, but is very successful at creating barriers to transparency. We have at least 4 major concerns that still haven't been addressed, and we've been complaining about them for the last 4 months. It's very clear that they won't be addressed at this point. And we have another handful of concerns that are unclear or vague, allowing agencies to sue requesters, non-starter, special services fees being presumed reasonable, non-starter. None of the government folks here have even been able to defend this, which I think Senator Scanlon has caught on to. There's no sending to multiple agencies, which is another non-starter. Fee shipping, which you tried to paint this all about, clearly a non-starter. We need to go back to the drawing board on all of these things. If we want to modernize OPRA, let's have conversations about what that actually looks like. If we want to deal with commercial requesters, let's have conversations about what that actually looks like. But let's not lie about what the intent is and try to pass a bill that doesn't do any of that stuff. This bill is a slap in the face to New Jerseyans and to the democratic process. Thank you for the opportunity to speak.
If you have spoken, please step away so allow the other folks to speak. And I just want to reiterate thanks to the ACLU for participating in a very good dialogue. I'm not sure what that individual was talking about, but ACLU participated. So, thank you to the ACLU for your participation.
Thank you, Chairman and members of the committee. My name is Antoinette Miles. I'm the State Director for New Jersey Working Families Alliance. I will try not to be too redundant on what the previous panelists have said, But I just want to be abundantly clear that we are still opposed to this bill in the current form that it's in, despite the amendments that have been made. I will acknowledge that there has been dialogue, and we appreciate that after 8 hours of testimony, public outcry, a poll that says 81% of New Jerseyans do not approve this bill, that you did the minimum to have meetings and have conversations about what needed to be changed. But still, let's be abundantly clear that without addressing the fatal flaws that still remain in this bill, this legislation still remains untenable and should not be passed. I want to be very specific to the bill and the amendments that have been made. I think that there is a narrative that is being pushed as it relates to cottage industry and greedy lawyers. But when I talk to folks in community down in South Jersey where I live, in places like Camden, folks that have been fighting for years for government transparency and government accountability, those are folks who, again, who are in the poorest city in the state of New Jersey that do not have the exorbitant amount of money to be able to go ahead and make sure that they are able to enforce their rights under the law. So if you gut the core enforcement mechanism of OPRA, which is fee shifting, it will make it show that there is a chilling effect and that regular everyday people will not be able to get access to the public records that they deserve. I also want to speak to the fact of creating what it seems to be a system of haves and have-nots. I do not understand why it was allowed to have commercial requesters be able to simply pay an additional fee to get an expedited response on a request in a matter of 7 days, when the press and everyday people cannot do that. And I also want to address the fact that this bill amended does create an additional barrier, a new and an unnecessary measure that prohibits sending a request to multiple agencies. We often know that, especially in state government, right, that there are agencies, multiple agencies that may carry a document, and putting the burden on the requester to understand which agency actually has it, it seems like it's going to be like shooting fish in a barrel and not something that the average everyday person can actually accomplish. And so I want to be unequivocally clear that, again, we do not support a bill that puts up barriers for the public. Yes, amendments were made. There is still work to be done. And do not mischaracterize us meeting with you as a way to say that you can act against the public interest. Thank you.
Folks, we've asked on numerous occasions to avoid the applauses. We're all sitting and listening, but I just actually respect the process. We're respecting the process. Please respect the process.
Hopefully we can trust the process as well. Doug O'Malley, Director of Environment, New Jersey. Privileged to speak to the chair and four members of the committee. We're obviously going late here, but I do want to say from a process perspective, having a committee vote in the Senate, the next day in the Assembly, and a floor vote on Monday is rushed. That itself speaks to a process that is not transparent and a process that honestly should be slowed down. The concerns you're here today should give everyone pause. And Environment New Jersey is proud to join this broad coalition of democracy and good government reformers, also acknowledging that plenty of citizens, local organizations, regional organizations, and state organizations have used OPRA over the course of the last 20 years for environmental protections. I will speak more on the amendments, but I do want to directly bring up in response to some of the things we've heard. We clearly think this bill and these amendments are still fatally flawed, and I think it's critical to remember that if we are allowing government to define transparency, and we've already heard testimony today that sunlight is the best disinfectant, but if we are allowing government to define transparency, you might suddenly find yourself in the dark. And that's why what I think is notable, the two largest cities in New Jersey, Newark and Jersey City, those mayors, Mayor Phillip and Mayor Braca, are opposed to this bill right now because of these fatal flaws. That should be a huge red flag. I think it's also important to understand we had testament before talking about the FDU language on whether New Jerseyans are supporting this bill. I think if you use that language, or really any language that says New Jersey citizens should have more transparency, more access to government, people would say, yes, that's why that number is so high. That's why it's 81%. It's also critical to know that we are here in 2024, but more than 2 decades ago, we had the same debate, and we had a bipartisan coalition led by then Assemblyman George Geist, supported by Speaker Collins, and then the godfather of transparency, Senator Byron Baer. Byron Baer pushed for this bill. Byron Baer got his start in government in many ways by being an activist. He was a freedom rider. He marched in Selma. He was in jail in Mississippi for 6 weeks. That should inform his approach. His position was taken over by Senator Loretta Weinberg, the former majority leader. She obviously has opposed this bill. I will say clearly you've heard enough on fee shifting, but allowing agencies to sue requesters has a chilling effect. Prohibiting sending requests to multiple agencies as a chilling request, and then the level of specificity required for requests essentially ensures the only way you can do an OPRA request is if you know what you're looking for. You have to allow the public to be able to get this information and not to allow agencies to define seeking records with the intent to substantially impair agencies. That is a catch-all that will obviously stop the intent of OPRA. Thank you so much.
Good afternoon, Camden, where I'm a proud alum. I'm a staff senator to our university senate, and I'm also a doctoral candidate in our community development program. I wrote this because this is my first time doing anything like this, and I wrote it sort of to echo the first speaker from today. And it's titled, "It's Not Lost on Me." It's not lost on me, and it's not lost on the New Jersey public, and increasingly the broader American public, what is happening here in the state of New Jersey. 19 county clerks appealed a federal district court ruling and took the case against the unconstitutional county line ballot design to the Third Circuit Court of Appeals, where again, a method which is statistically significant in documentation of rigging primary elections only in the state of New Jersey was ruled unconstitutional. And not for nothing, the public should be able to know how much money those county clerks spent on defending the unconstitutional and racist ballot design without risk of themselves being sued for asking such questions.
You haven't done one thing about an amendment. You haven't done one thing about the bill or amendment, so you can get all the claps you want. I'm gonna give you 3 minutes, and I'm gonna let you speak for 3 minutes, but you haven't spoke about the bill or the amendment.
My apologies, sir, that's
So
my
I'm
next
gonna give you 3
paragraph.
minutes to read.
Thank you, sir. Like I said, it's not lost on me that following the death of the county line ballot design, the New Jersey legislature has gutted the Election Law Enforcement Commission. It's now trying to gut the Open Public Records Act, all while proposing to gut the power of the state comptroller after the comptroller cited powerful government officials for abuse. And now there's this wild proposal to politicize the judiciary as well. All of these acts amount to the precipice of what can be seen as a total government capture. And I will respond that I do encourage each of the senators here on this committee to vote no against these amendments, especially the item related to fee shifting. I can say that in my past, I have submitted OPRA requests for various items, and if there was the likelihood to be sued for submitting an OPRA request, or if there was the likelihood of being liable for hundreds of dollars in fees, I wouldn't ever consider doing that, thus letting government continue to do.
Thank you, sir. 3 minutes. Thank you.
Of course, have a great day.
Elisa Feinstein, Sharon Steinhorn, right here. Elisa. Sharon, come on up. We have a few people from and just let me know who's representing Food and Water Watch. We have a few of them. New Deal of New York, Mike Davis. Come on up, Michael. Nick Sedano. Come on up, sir. Tiffany Fisher. Matthew Hirsch. Sam DeFalco. And Charlie Cratmo. Okay, just have a few left. Start, my right, your left, we'll go zigzag. Thank you. 3 minutes, folks, please let us know what amendments you are talking about.
As a concerned parent invested in our state's public school system, and as a taxpayer contributing to its funding, I'm deeply troubled by the potential repercussions of the proposed OPRA amendments. Our school districts, serving as guardians of our children during school hours and largely funded by our property taxes, bear a significant responsibility. Yet when questions arise about their expenditures and actions, parents' recourse is often limited. It is through mechanisms like OPRA requests that concerned citizens uncover fiscal irresponsibility and breaches of trust. Take, for instance, my town of Rantock. During the pandemic, parents noticed odd entries in publicly available documents, prompting OPRA requests that have unveiled questionable spending practices, such as extravagant office redecorations and ESSER funds used not to address learning loss, but to repay the parking lot. At the same time, our superintendent called our test scores abysmal. These findings were reported to the NJDOE, sparking an investigation. This past October, our business administrator, who is also the records custodian, refused to answer parents' questions about district spending, and then attacked parents in a 7-minute defamatory speech for questioning his actions, including charging a per-child mandatory device insurance program fee that had no insurance policy attached to it that was discovered via OPRA. After using OPRA to learn, the business administrator and his staff drafted the speech on taxpayer-funded time. 2 OPRA requests for his email logs for the days around his speech were then delayed more than 130 days. Some merely citing his workload. A 3rd OPRA request, seeking an expert report showing that our turf fields no longer needed to be replaced, which the year prior were in dire need of being replaced, also was extended. All 3 of these OPRA requests were automatically became in complete denial when the business administrator missed his own heavily extended deadline on April 26th in the wake of his departure to another school district. However, in a misfired parting shot, his intention, based on the emails that arrived after the deadline, were to charge the parents almost $2,000 in special services fees for email logs, claiming it would take 30 hours to review and respond to those OPRA requests, and to give the district another month-long extension for the likely non-existent expert turf documents. Under the current version of OPRA, parents can file a complaint to state court and automatically have their legal bills paid if they're successful. We are taking that away, taking that away. Only if there's a showing of bad faith can we get fee shifted. No parent is going to go after documents, particularly when we're being nickeled and dimed right now due to S2. And it's too risky for an experienced lawyer to take this case on now. We're not commercial entities. We're moms and dads seeking critical information about how our local school districts are being run. I just have 2 more lines. How our tax dollars are being spent because it affects the most important people in our lives, our children. OPRA is our only recourse when our school boards of ed and school administrators refuse to communicate. We risk being left in the dark, unable to hold accountable those entrusted with our children's education and taxpayer dollars with no recourse. Thank you.
Thank you.
Good afternoon, committee members who are still here. I'm Sharon Steinhorn. Good afternoon, committee members who are still here. I'm Sharon Steinhorn, co-president of the League of Women Voters of Monmouth County, representing over 300 Monmouth and Ocean County members in legislative districts 9, 10, 11, 12, 13, and 30. And thank you to my senator for being here in 13. And all of you who remain, we remain vehemently opposed to attempts to roll back the Open Public Records Act, gutting important provisions we rely on every day. The amendments to this bill were unofficially released through the press just this week, disregarding our calls for more time for the public to properly evaluate the contents of this legislation. And even with limited time to review the amendments, we can see that many problematic provisions remain as wolves in sheep's clothing. You changed the language, but did not address the core issues. For example, as many have mentioned already, the changes to fee shifting still make it difficult for the public to be able to find legal representation. The changes to harassment still enable the public to be sued for vague and unclear reasons, and it still remains difficult for the public to get access to the records they need. It is time to listen to your voters and vote no on this bill once and for all. And for 104 years, the League of Women Voters has worked to empower voters and defend democracy. And this bill, with its amendments, hinders that mission. Please vote no.
Afternoon, Senators. Mike Davis, acting chair of the APP at JAGO, which is a labor union representing journalists at the Asbury Park Press, Home Tribune, and Courier News. You sound facetious, but genuinely I'm speaking to all the amendments I've had a chance to digest. I appreciate them all, the Guild appreciates them all, but they just do not go far enough. This is still a fatally flawed bill, and we would ask that you hold it for now, if not kill it outright. The bill, under the amendments, we are still severely limited in the kind of records and the scope of records that we can obtain, more than we already are today. Even if we meet the ridiculous standards that are put on us in requesting records, we can still have them denied for these really, really broad reasons that people have spoken to already. Leaving it up to custodians to decide what's considered harassment or what would compromise the integrity of the security system. Those are probably reason enough to tear this bill up. But last time I was here, I gave a number of examples of important journalism that couldn't be done under this bill, and that's still the case, including these amendments. I'm not going to repeat those examples, but I am going to give you more. We've already talked about the New Brunswick Today video, shout out to Charlie, with Edison police making jokes, cracking jokes at Caesar migrants. There is the mayor of Spotswood yelling at her own cops for not keeping a black guy out of town hall fast enough because, and I quote, "This is not a diverse town." That's from my colleagues over at mytracer.com. There's video of that incident. The mayor doesn't want it out there, and if it weren't for fee shifting, I don't think we would be able to fight the fight that we were fighting to get that released. That's too small, if that's too politically tricky. We can talk about the older veterans' homes who treated the COVID-19 pandemic so lightly that it led to dozens of deaths of veterans. I'm sure you are all aware of that situation. I'm sure many of you put out statements decrying it, calling out the horror of it. But under this bill, that work wouldn't have been possible. OPRA allows us to report stories on nameless, faceless LLCs who are completely wiping out the housing market. The old superintendent of the Central Regional School District got paid $200 grand to go away after he leaked out details of students' suicide to a British tabloid. And then there's the officials in Asbury Park that blew through $2 million in rental aid, and they literally opened an Airbnb instead of building affordable housing for the people who needed it. All of those stories get harder and harder to report. In a lot of cases, they go nowhere under this bill, even with the amendments. But I think what really scares me and scares the Guild it's not just making it harder to obtain public records, but they are deliberately written to scare us away from it, to essentially say, I dare you, let's see how bad you really want these records. You can sue members of the public because we filed too many requests. We've already talked about fee shifting at length. And I understand that there were changes to the language and some of this stuff, but it just doesn't go far enough. I would just close with, I realize I have the yellow sign already, but I've been really careful not repeating myself and things I said last time. But I will say this, everyone in government, again, likes to talk about transparency, but you don't get to talk about transparency, just say it out loud and have it magically happen. It requires work, and it is a lot of work, I admit that, and it's a lot of hard work. But that's how democratic society operates. You have all these people in this room that are telling you that you're scaring them away from democracy. When you all took office, you took on that mission. I hope you take that mission seriously. Thank you.
Thank you, Michael. Folks, the music in the front, thank you for your testimony, politely, so we can see. folks in the back.
I was told to come forward.
You're right. You want to move forward? Yeah, come on. There you go, sir. You're up.
Hello, Nick Sedano. I had the unfortunate timing of creating a nonprofit newsletter, hyper-local journalism for my town, you know, at a time when journalism, newspapers are dying. I wanted to focus on my town because a lot of people don't know what's going on. So, you know, it's kind of my hobby. I turned it into, well, I'm going to be a journalist right as the Open Public Records Act is about to be killed. So I wanted to speak to, I guess the amendment would have to be about the suit part of the legislation. And I was advised before I created the, you know, the whole corporation and all that stuff that, you know what, you're going to get sued. You need insurance. You need an attorney. So I borrowed the money to do that. And what was one of the first emails I got from the administrator? You can be sued for harassment because you're harassing me about some money of a loan that went south, UEZ money. I just wanted to look into it. That's harassment, I guess. So I also want to tell you I was an interim council person for 3 months. Somebody left town, they brought me in. And when I got sworn in, I got to see behind the curtain what it's like for that township clerk. And that is a busy office. There is so much going on, phones, you know, people that want to speak in person. That person's busy, and their staff isn't that big. So I get it, you know, the burden of responding to OPRAs, especially if there's like tons of them, can be overwhelming. So, but I see it as a budgeting issue. You budget for your priorities, and like the one wanted said, was up here, it said, they need more staff. Well, if you guys can figure out how to make a corporation stay in New Jersey and give them a $118 million tax break, you can find the money for more staff. I'm pretty sure you can do that somehow. So budget your priorities, and transparency should be in the budget. Thank you.
Thank you. We're going to continue going from my right to your left, 3 minutes, please. Thank you. Okay.
Hi, okay. My name is Tiffany Fisher. I'm a city council person in Hoboken, New Jersey. I testified the last time we were before you about a month ago. Another council person was up here earlier, Tara Astor from Mount Holly, and basically everything she said, I agree. As an elected official, you know, OPRA holds me accountable for not acting in a dishonest, corrupt way, and I'm happy to be held accountable for that. And I know that hopefully everyone here feels the same. As a member of the public, I want to have access to information, and OPRA allows me to do that. Just a couple quick things that I don't know that have been addressed today. You know, in the first instance, when we talk about fee shifting, you know, you have to really look and think about who this impacts the most, right? This isn't going to dissuade a commercial user. It's not going to dissuade a large, well-capitalized developer from filing a request. Those requests will still come because they'll be able to afford the legal cost to defend and try and access that information. What this really does is this is going to limit the lower income people from accessing information because they won't have access to lawyers to help defend them to get this information. And with lower income, as we know, we have a disproportionate of Black and brown and minorities. And all of these senators, especially the ones walking out the door and leaving us today, have, you know, our job as elected officials is to make sure the laws work for everyone, and certainly not just the wealthy. And so we should really be thinking about the impact that fee shifting has on the people that need it the most, and really the ones that we rely on to be elected. The second thing I would say is the area that I have a big concern with is allowing government agencies to sue the public. So think about that for a second, right? We are weaponizing our government to attack the public.
As a country, we fight countries that have that type of government. That's not a democracy. And so what we're doing is putting forth a bill that says it's okay for our government agencies to attack the public and use taxpayer dollars to do that. And you can do a lot with other people's money. So as you're thinking about, this bill, this is an anti-democratic bill, and it takes us in a direction towards governments that we fight against every single day, and it discriminates against those in our community that need our support the most. So I hope you consider that in your decision. That, just very quickly, I support reform, and what I'd like to see everyone do is putting money in the budget to allow municipalities to automate their OPRA processes, because that's where I think you'll get the biggest bang for your buck, and that would be beneficial to everyone. Thank you.
Hello, members of the committee. My name is Sandra Falco, and I'm an organizer with the organization Food and Water Watch, speaking to share our concerns with the amendments of S290 and our opposition to the bill at large. Food and Water Watch is a climate and environmental organization that works to advocate for climate action and healthy environments. Key aspects of our work include working alongside frontline communities to stop fossil fuel build out and working to stop corporate takeover of water and sewer systems, both of which necessitate us to do research from data which is often sourced through OPRA requests from state agencies and municipalities. This bill falls short of introducing changes that would improve OPRA and make it more efficient to access records and hold our government accountable, and instead creates significant and unnecessary hurdles to the public's right to access public records. We are concerned about the fee shifting amendment. Fee shifting is the main enforcement mechanism for OPRA. If this is eliminated, communities living near and most harmed by polluting industry and fossil fuel build-out, or who face privatization of municipal water systems, which in New Jersey, these communities are almost exclusively low-wage communities, may not be able to attain an attorney to represent them or to challenge improper OPRA decisions. Communities deserve access to public information about industrial projects that will impact their life, but with the cost of legal representation shifted onto them, it will make it nearly impossible for residents to obtain legal representation in cases where OPRA decisions must be challenged. Additionally, we have major concerns with the amendment allowing government agencies to sue requesters. There's not enough specificity in the language of what intent to substantially impair the performance of government function to know how this could be interpreted by agencies. Sometimes we need to submit large requests or submit multiple times to acquire the information we need. We are concerned that this could open the door to allow agencies to retaliate requesters, especially as it relates to our work, because we are running campaigns to get multiple state agencies to drop proposals for new polluting projects, which are often the agencies we're requesting these OPRA requests from. So please vote no on S290 to prevent access to critical records and the enforcement mechanism to challenge decisions. Thank you.
Should I start? Oh, hi, Charlie Cradville. I'm the editor of New Brunswick Today and a board member at the New Jersey Foundation for Open Government. I'm testifying on behalf of both organizations today, but first I just want to say how proud I am and grateful I am for all the speakers who took time out of their day to oppose this ill-conceived, anti-democratic abomination. It's not the first time we've had to do this. I also want to draw your attention to the March 11th hearing in this room on this same bill. I know that many members of the board, many members of the committee left that hearing early, yet still cast votes without hearing all of the testimony. So I hope that any member today that was not present for that hearing will abstain from voting today unless they've reviewed all of that testimony. I also think that cutting the fee-shifting enforcement mechanism remains extremely problematic in its latest form, and preventing this grave mistake remains our top legislative priority. The current language will actually cost taxpayers more when there are OPRA cases because it's very hard to prove bad faith. It will almost always require that the cases enter discovery. and therefore the cases will be more complicated and costly to the government and waste more of the judiciary's time. And I also have to ask, because it's come up many times, here in the amendments that are available over there, page 24, section 8, is it fair to say this section empowers government agencies to sue their own citizens, Mr. Chair?
Excuse me, sir?
Is it fair to say that section 8
Why don't you finish your testimony, and we can have a dialogue. Finish your testimony.
Okay, I look forward to a dialogue because I brought this up last time and you said it wasn't in the bill, but
Sir, finish your...
I'm looking at it with my eyes here. Okay.
You're using 3 of your precious minutes, so please.
Okay, well, this is atrocious. As has been mentioned, this is an un-American thing for the government to be suing their own citizens, and this bill empowers it. It should be banned, not empowered. I also encourage you all to read our latest article on NewBrunswickToday.com. It was mentioned. This is a perfect example of an OPRA case where the agency was wrong, but it took the use of that enforcement mechanism, fee shifting, to force the release of the records. And whatever you think about what's in those videos, overwhelmingly people will agree that we are all better off for being able to see them and learn what actually happened. This case would not have happened if not for the fee shifting provisions in the current version of the OPRA. These changes will disempower and harm access to information for low-income people, small businesses, local news outlets, all of us who don't have extra thousands of dollars sitting around to fight a legal case. So one final point, please don't perpetuate the fallacy that stakeholders were consulted. New Brunswick Today has reached out to your office 3 times and got no response. You did not meet with New Brunswick Today, and you did not meet with the New Jersey Foundation for Open Government. So I would just say that you need to take a step back, listen to the advocates, meet with us, learn about the OPRA, and put the brakes on this bad idea.
Okay, any questions? Okay, thank you. Thank you for the panel.
Yeah, can you just answer about my questions? Section 8. Does it empower governments to sue their own citizens? Is that fair to say?
Yeah, I think you're misreading it, sir, so we can have a debate at another time. I think
Okay,
you're
many people spoke.
I just want
your take on it.
You had your piece, let me say my piece, okay? You could, please.
I can't hear you.
As for the video piece, there's nothing in this bill other than prohibiting videos of people's intimate body parts that are prohibited. You still have access to all police video.
You must be confused. I'm asking about Section 8 on page 24. This would be the provision that allows for a verified complaint in Superior Court against requesters. I was asking, is it fair to say that empowers governments to sue their own citizens?
Thank you. You provided your testimony. We have no questions for you. Thank you. Sure, please, thank you.
I asked the question. You said you would answer, and now you're not.
I didn't say I was answering it. So if anybody had questions afterwards.
Well, the public deserves an answer.
Yes.
Thank you, misreading. Thank you. Have a great day. Okay. Herb Torbus, is Herb here? Matthew Hirsch. And then the last person to sign up is Joe Cohen here? Come on up, Joe. Paula Rogerman. And the last one, these are the last 3 we have signed up for testimony. Tyrene Howard. Denise. Okay, if you could just go over to the sergeant and give me your name, I don't have it, but we'll find it. Yeah, sir. Three minutes, we're down to the final panel. This is the final panel, so 3 minutes after you get done speaking, please just step away unless there's any questions for you.
Thank you, Mr. Chairman. My name is Joe Cohn. I am a civil rights lawyer, a free speech lawyer. I was the former legal director of 2 ACLU affiliates. I've been the head of the legislative and policy department in an organization called FIRE, that does free speech work across across the country. And I'm currently a candidate for Congress in the New Jersey 3rd Congressional District. And thank you. And I'm very frustrated to be here because it's preventing me from talking to voters. But I thought it was really important because the problems with the bill that you've heard are numerous. The fee shifting, just as an attorney who's dealt with that from a nonprofit public interest law perspective, you only get the fees if you prevail, meaning that the government was wrong. And it only climbs if they dig in their heels, and they dig in their heels until you have to prove it right at a higher level. And even then, courts are allowed to make sure that the fees are reasonable. The problem with making it so that it is conditional on the court deciding to award them is that you'll never be able to find lawyers who are willing to take the case. And even then, you only have an entitlement when there's bad faith, which means that every case is going to have discovery, as you heard from a prior witness. That will dramatically increase the cost to the state for each of the lawsuits. But I'm really disturbed as well about the provision that allows the government to sue people if they think that there's an intent to harass the people denying the records. That's a real bad precedent to start. And I won't go further into that because it's been covered already. The provisions about the specificity of the requests are also problematic because you often don't know quite as many details about the specific name of the people. Less than 8% of people know the name of the member of Congress. What percent of people do you think understand the names or the position and titles of particular employees of government agencies? 0%? 0.0001%? It's just so few. And then, not being able to submit it to more than one agency at a time, I think, is a deep problem. I won't go into that any further. I think the better approach is to make sure that you invest the money to digitize records so that complying with requests is less burdensome on the employees moving forward and cheaper to accomplish. And, I think that as well as investing in more personnel are the right approaches here. And I agree with the testimony that this poses tremendous threats to democracy that we've heard across the day. And that's the theme of my campaign, is doing what we can to protect democracy. And I'm concerned about the threats that I see in other states, where it's mostly the opposition party. But here, we have to defend democracy ourselves every time it's in front of us if we want to have credibility across the map in the other contexts.
Thank you, sir.
Thank you so much.
Thank you.
My name is Paula Verhoeven.
Please take your button.
Is this working?
Yeah.
My name is Paula Verhoeven.
1 second, ma'am. If you can just take your microphone off, there we go. Now we're good.
My name is Paula Verhoeven. I'm a member of the League of Women Voters of Teaneck. The League has long supported real transparency reforms that strengthen our democracy and that are designed to increase engagement and public trust. This bill is not that. I urge you to vote no on S-2930. Even with the amendments, S-2930 decreases government transparency and access to public records by gutting the existing law and making it more difficult for the members of the public that the government serves, to access records. Many folks, many people, including myself, testified in March regarding the flaws in this legislation that negatively impact the public. These flaws remain, specifically gutting, fee shifting, and creating unnecessary hurdles and barriers for the public. OPRA provides access to information that can inform our thinking and our actions in a democratic society. To deprive the public access to essential information puts our society at great risk. The same has been true for the environmental justice work that many of us have been involved in since my retirement in 2018. Retirement from teaching in 2018. OPRA impacts New Jerseyans across the state, and the public is not in favor of this legislation. Despite a short time frame between this bill's amendments and its scheduled committee hearings, we continue to see massive amounts of public opposition by New Jersey residents, nonpartisan organizations, government agencies, the media, current and former public officials, and more. We have shown up here today to shine a light on what is really in this bill,
I hope the members of this committee will listen. The League has always stood strong in the face of attacks on transparency. I urge this committee to vote no on S-2930. And I have this sign for you. It says, vote no on S-2930. Don't shred our democracy. Don't shred our democracy. Don't shred our democracy. Don't shred our democracy.
Thank you, folks, man, thank you. Please step away. Sure, you're up.
The last one?
You're, no,
I can, Janine Howard. Your button, sir. This thing on?
Yeah.
Hello, my name is Janine Howard, former employee at the New Jersey Department of Transportation, where I was the principal planner. I think this bill would mess up my theory that New Jersey Department of Transportation discrimination is causing problems with New Jersey against black men. And this law would prevent me from doing my research to get that information. I've been trying to get information. I think Senator Singleton has been trying to get information, but DOT doesn't seem to want to give it. This OPRA request provides the tool necessary to get all that information from all those years, 7 years back, maybe even 10 years back, to determine my theory that I'm working on. I was employed there. I was involved in various things like the Transit Village Initiative, statewide planning, various things that probably will help New Jersey Transit lower their transit fare, or keep their transit fare. But they're not as open to new ideas, good ideas, it's just the same old, same old. I think there needs to be some new blood, some transparency, especially the New Jersey Department of Transportation and the New Jersey Trust Fund. Just like the State Transportation Trust Fund, there needs to be transparency. There's various programs, everybody's doing their own thing, they only have their own fight films and all that stuff. And this law would just let that stuff go on. So, vote no.
Thank you, sir.
Thank you.
Mayor? Okay, last one.
My name is Sandra Maxson. I'm a member of the League of Women Voters of Somerset and Hunterdon County, but I'm really here today as a citizen and a voter who has followed and testified on open public records legislation since 2002. There's no question that the current law needs updating, but it needs updating to improve the public's access to information, not to make it more difficult. And I maintain that S-2930 does make it more difficult. To the amendments, yes, you clarified commercial purposes by listing what it does not include. I'm not sure that that addresses the municipal clerk's concerns about the number and cost to fulfill those requests. You allow for requests to now be made by letter or email, unless I misheard a late-minute amendment. But in that amendment, you say that as the requester, if I don't use the adopted form and I put in too much information, trying to help tell you what I'm looking for, you can deny the report. And yes, thank you very much that blogs, telephone calls, emails, texts are now considered open public records, which in the before these set of amendments you had removed. You've heard almost all the other changes, which I think make it harder to access, prohibiting requesters submitting requests to multiple agencies, adding the requirement that if I want to challenge a fee is unreasonable, I'm the one who has to show that it's unreasonable. Increased specificity when you're asking for emails are required. And of course, what no one wants to leave out is, of course, the fee shifting, which really, I think, makes it more difficult for citizens to obtain legal representation if they want to challenge a denial. I don't believe the bill before you modernizes the Open Public Records Act. It does not make it more efficient. easier or faster to access records, to help understand government activity and to hold government accountable, and would ask that you vote no. Thank you.
Thank you, everybody. That concludes the testimony. I want to thank everybody for coming down and testifying on behalf of the updated bill. We appreciate your patience. Before we take a vote, just a little update. It appears the supplemental funding bill is still under negotiation. Senator Zwicker, is that correct? As one of the sponsors. So what we're going to do is take a few-minute break. I apologize to those who came down early for the supplemental funding. We're going to jump into higher ed, conduct the higher ed hearing, and then we'll come back to the supplemental funding bill. We may take a break in the middle of that if the language is ready. Move the bill. Motion on the bill. Cruz Perez, first. Second. Roll call.
And Mr. Chairman, I just want to note that there was one small technical change made to the bill to define labor organization as an organization which exists and is constituted for the purpose in whole or in part for collective bargaining or dealing with employers concerning grievances, terms of employment, or other mutual aid or protection in connection with employment. Just for the committee's knowledge.
Essentially, it just further clarifies that labor organizations are exempt in their negotiations with public agencies. They have full access. They don't need to go through the OPRA process. Got it. Okay. They're fully exempt from the vote.
This is a vote on S2930, first reprint with committee amendments. Senator Amato.
Yes.
Senator Singer.
Left a yes vote.
Has left a yes vote. Senator Testa.
Mr. Chairman, if I can make a comment prior to my vote, I'll be very brief. In my 4+ years in office, it has become very apparent to me that the public is starving for more transparency and accountability in government, not less. And while I understand the good intentions of the sponsors of this bill, I just think that the public perception concerning this bill and the particular contents of the bill restrict that transparency and accountability in government, and therefore I must be a no. Thank you.
Senator Testa is a no. Senator O'Scanlan.
Like Senator Testa, we actually dynamically react to things we hear from folks. The respectful comments today, heard loud and clear. I do want to take some issue with folks demonizing the sponsors of this bill. I think that the goal here is honorable. I've spoken to Senator Scutari, I've spoken to Senator Sarlo, and some of the other folks involved in this. While I'm going to vote no today, I believe that their hearts are in the right place. And I believe that at some point, actually, we're long overdue for some level of OPRA reform for a lot of the reasons we heard from the people backing the bill today. I just don't think this bill is there yet. I think there are still some significant flaws, as we heard today. And I have yet to meet with folks on both sides of this, because we just got the amendments the other day. So I have to be a no today. I'd like to get to yes, because we do need to address some of the concerns with OPRA. I'm just not there today, so I'm a no vote.
Chair Sarlo.
Thank you. Thank you to everybody, as I said, who came down. Thank you for everybody's input. I was asked by leadership, as part of the leadership team, to take a look at this. Clearly, it's something we needed to do to modernize OPRA. If we didn't get to everybody's issues and concerns, I believe it's a step in the right direction. We always have the ability to go back and make further amendments, and that's part of the legislative process. I vote yes.
Chair Sarlo is a yes. Vice Chair Greenstein.
Thank you. I was an early supporter of OPRA back in 2001. I was in the legislature then and worked on it. And I think it's been very successful in many ways. However, there definitely are changes that need to be made, and I believe that's what people were trying to do here. The changes were not meant to make records less accessible. just to update the law and get rid of abuses. We're hearing today that a lot of people don't feel that it's going to do that. I know that that was the intention. Today I'm going to vote yes, in spite of, I know, many people's feelings in here, but I reserve my right on the floor to go in the other direction. I want to, as a few people said, we just got some of this material a couple of days ago, and I want to get completely up on everything. So I'm moving it out of the committee, but by the time it gets to the floor, I want to have more knowledge and could change my vote. Thank you.
Vice Chair Greenspan is a yes. Senator Ruiz
Yes.
is a yes.
Folks, please respect the process, please. Please. All day, nobody has respected the process.
Senator Cruz Perez
Yes.
is a yes. Senator Scutari
Is a yes.
left the vote in the affirmative. Senator Crine left the vote in the affirmative. Senator Zwicker.
Thank you, Chairman Searle. Thank you to you for all the work you've done, to your staff, staff majority office. I know how much hard work has gone into the last few weeks. Much like Senator O'Scanlan, there's no doubt, and others have said, that we need to modernize and reform OPRA, but the concerns that I've heard today raise serious issues when it comes to not just government transparency, but how we are shifting the burden onto the requester in ways that I think will take us a step backwards. So at this time, I'm a no.
Senator Zwicker is a no. Senator Burgess
Yes.
is a yes. And Senator Burgess-Chalmey.
Chairman, if I can add a comment as well. I thought the testimony today, in most part, was very thoughtful. And one thing stands out that I think your original suggestion after the last hearing to include a cap to allow for fee shifting to stay in place with the $300 cap would have served us and can serve us better. I'm hoping this process will continue as we move to a full session vote, that there is some consideration going back to that. I'm also going to vote yes to release the bill with reservations heading into the voting session. Thank you.
Senator Burgess-Chalmey is a yes. S2930 first reprint is favorably released with committee amendments.